Good morning, ladies and gentlemen. The meeting will now come to order. Welcome to this meeting of the Charlotte Unified Development Board of Adjustment on September the 26th, 2023. My name is Deborah Dryden. I'm the Vice Chair of the board. Also sitting on today's board is Hamilton Court, Amy Sun, Marsha Williamson, and Kevin Shea. Also present are Lisa McCarter, our Planning Project Manager, Solomon Fortune, the Zoning Administrator, Therese Hagler Gray, Senior Assistant City Attorney and Advisor to Staff, Nicole Hewitt, Assistant City Attorney and Advisor to the Board, April, who is sitting in for the Clerk of the Board, and Candy Thomas, the Veritex Court Reporter. Each of today's hearings is a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how the board must make its decision. These rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. Quasi-judicial decision is not a popularity contest. It is a decision constrained by the standards in the ordinance and based on the facts presented. If you will be speaking as a witness, please focus on the facts and ordinance's standards, not personal preference or opinion. Parties with standing have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the city, and individuals who can show they will suffer specific damages. Other individuals may provide testimony as witnesses when recognized by the board. Witnesses must swear or affirm their testimony. Any individual wishing to speak as a witness today was required to sign up. If you haven't done so, please do so now. See April. General witness testimony is limited to facts, not opinions, and for certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic. Individuals providing expert opinion must be qualified as experts and provide the factual evidence upon which they base their expert opinion. While hearsay evidence is not specifically excluded, it is only given limited weight. The parties to each case are entitled to an impartial decision maker. A board member may not participate in a hearing if she or he has a fixed opinion about the matter, a financial interest in the outcome of the matter, or a close familial, business, or associational relationship with an affected person. The parties to each case also have a right for an ex parte communication to be disclosed. Ex parte communication is any communication about the case outside of the hearing. That may include site visits as well as conversations with parties or the general public. At the start of each case, any potential conflict of interest or ex parte communication should be disclosed by a board member if applicable. These matters may also be raised by any affected party. The procedures are: today's meeting will follow the order printed on the agenda. The board will hear types of cases and applications for a variance from the regulations in the zoning ordinance or UDO. The order of the recommendation agenda will be as follows. The zoning administrator or zoning staff member will identify the case and recommend approval of the variance with any recommended conditions based on specific reasons. The chairperson will ask if anyone wants to speak in opposition. If there is such a person, then the case will be moved to the regular agenda and will be heard at a later time. After staff's presentation, the chairperson will ask if the board has questions for staff or if there's any reason the board wishes to move the case to the regular agenda. If a board member has concerns about approving the variance, the member should request to move the case to the regular agenda so that the applicant may have an opportunity to present its full case and answer any board member questions. The chairperson calls for a motion and a second to approve the variance, the chairperson will hold a roll call vote. All parties who plan to give testimony must be sworn in. All zoning staff member will present a summary of the variance request. The board may question the staff member, and then the applicant may question the staff member. The applicant presents their testimony for the case. Now, this falls under the regular agenda, not the recommended agenda. I apologize for not making that clear. The board may question the applicant, and zoning staff may question the applicant. The applicant may present other sworn witnesses. They will also be subject to questioning by the board and staff. Other parties wishing to speak for or against an application will be given reasonable time to present sworn testimony. The staff and then the applicant will be given an opportunity for rebuttal. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each case. The chairperson calls for a motion and a second to approve or deny the variance. In the case of an appeal, the chairperson calls for a motion and a second to uphold, modify, or reverse the administrator's decision. The decision will be made by a simple majority of the board. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning staff after the session to receive the decision of the board. All exhibits must remain with the board. If your case is not appealed to Superior Court for 30 days, you may pick them up or they will be destroyed. Appeal from the board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to appeal, in accordance with NCGS 160D-405D. In order to receive a written copy of the decision, any aggrieved party must file a written request for a copy of the board's decision by filling out the form, which must be filed with the board's clerk or chairperson at the time of the hearing of the case. All right, in the presentation of the case, we will now open the evidentiary hearing for, and Lisa, may I swear you in, please? Ms. Carter, do you swear and affirm that the testimony you will give is true? I do. Okay. All right.
I wonder if is there a way to get the slide further up or? Thank you. The first case is a billboard variance. The applicant is requesting a zoning ordinance 1,110-foot variance from the required 150-foot separation from a Class 1 road to allow the conversion of a non-conforming static outdoor advertising sign to an electronic changeable face outdoor advertising sign. So I'll give you a minute to look over your findings.
All right, Lisa, you may continue. Thank you.
Okay, exhibit number 1 is the vicinity map. And then exhibit number 2 is the zoning map. The zoning is B2, general business. And then we'll go to exhibit 3 is the aerial map of the property. And then exhibit 4 is the close-up aerial map of the property. Exhibit 5 is background. The existing nonconforming billboard was constructed in 1978 and is static. It's the billboard to the left. The applicant would like to convert the billboard to electronic. The billboard doesn't meet 3 of the zoning ordinance requirements for the conversion to electronic. Electronic billboards in the B2 zoning district must be within 150 feet of the right-of-way of a Class 1 road, and this billboard is located 1,260 feet from the right-of-way of a Class 1 road, which is Interstate 277. Unipole is the only permitted type of sign support, and the sign currently has a multi-pole support. And the billboard must be located at least 500 feet from another billboard on the opposite side of the street, and the subject billboard is located 278 feet from a billboard on the opposite side of the street. And that other billboard is shown over on the right. And then we'll go to Exhibit 6. Exhibit 6 is the variance request. The applicant is requesting a variance from the 150-foot maximum distance from the Class 1 road to permit the conversion of the billboard to electronic. The applicant has worked with staff and proposed conditions that staff supports. They propose to change the support to unipole and remove the billboard on the opposite side of the street that doesn't meet the spacing requirement. The subject billboard is on the bottom right of the plan, and the billboard the applicant has proposed to remove is located towards Interstate 277 on Cherry Street. So 277, this is the billboard they'll remove, and then this is the subject billboard. And we'll go to Exhibit 7. Exhibit 7 is the variance criteria, and all must be met. And there has to be unnecessary hardship that would result from the strict application of the ordinance. The hardship results from conditions that are peculiar to the property. The hardship did not result from actions taken by the applicant or property owner, and the requested variance is consistent with the spirit, purpose, and intent of the zoning ordinance. And we'll go to Exhibit 8. Exhibit 8 is considerations. Staff supports the requested variance with the applicant's proposed conditions. The billboard has been on the property for 45 years, and the ordinance prevents the sign from being updated. The property is narrow in depth, ranging from about 10 to 20 feet, which is insufficient for a use that requires a building. And we'll go to Exhibit 9. Exhibit 9 is considerations. The billboard is non-conforming since it was constructed in 1978. The applicant's proposed conditions will bring the sign further into compliance. The applicant will remove the sign shown on the plan and in the photo below, since it doesn't meet the spacing requirement in order to come into compliance. And then we'll go to Exhibit 10. So you see over on the left is the existing multi-pole sign and the proposed unipole sign over on the right. And then Exhibit 11 is a photo of the property. And that's the end of my presentation. If you have any questions for me.
Does anyone on the board have questions? Oh, well, first, April, is there anyone in opposition to this?
No, ma'am.
No, okay. Board, do you have any questions for staff? Hearing no questions, do I have a motion to approve this variance?
Move to approve the variance.
All right, I have a recommendation from Mr. Court to approve this. Do I have here second?
Second.
And from Mr. Shea. Now we'll do a roll call vote. Mr. Court?
Court, yes.
Ms. Sun?
Sun, yes.
Mr. Williamson?
Williamson, yes.
Mr. Shea?
Yes.
Dryden, yes. So the appeal is approved. Now let's look at your finding of facts and conditions of law. And do I hear a motion to approve?
Court, motion to approve findings of fact.
Do I hear a second?
Williamson, second.
Williamson, second. Now a roll call vote. Mr. Court?
Court, yes.
Ms. Sun?
Sun, yes.
Mr. Williamson?
Williamson, yes.
Mr. Shea?
Sure, yes.
Dryden, yes. So the finding of facts is approved. Thank you very much. All right, we move on to,
Madam Chairwoman, just to clear up, you approved the findings of fact and conclusions of law?
yes. Sorry, did we not say that correctly?
I don't believe you said it at first, but just wanted to clarify.
Yes. We do approve the finding of facts and conditions of law as written. Okay. Let's see, the next case we'll hear is Lisa, go.
Our next case is 2023-053 for 7600 Harrisburg Road. The applicant is requesting a UDO 13.5-foot variance from the 27-foot front setback along Meisenheimer Road to construct a dwelling. And we have the applicant here. You don't need to speak. It's on the recommendation agenda. So if it's pulled off the recommendation agenda for any reason, then we'll have you come sit up here, but you don't need to speak.
I speak a little English, pero my property is close for this house. I don't know if possibly somebody help me for take everything for me, please.
Okay. Oh, okay. All right, we will pause this case and we'll move on to case 2023-006, the property located at 3620 Craig Avenue. Okay.
All right.
Okay.
This case is a rear setback variance, 2023-066, requesting a UDO 15-foot variance from the 35-foot rear setback to allow an addition on a non-conforming dwelling. And I'll give you a minute to look at your findings.
Okay. Okay, Lisa, you may continue.
Okay. Exhibit 1 is a vicinity map of the property. And then we'll go to Exhibit 2 is a zoning map. The zoning is N1B, Neighborhood 1. We'll go to Exhibit 3, which is an aerial map of the property. And then Exhibit 4 is a close-up aerial map of the property. Per the definition of setback, the property is a corner lot, and the front setback is along Nancy, and the corner side setback is along Craig Avenue. But the home is oriented towards Craig Avenue, which is the corner side setback. So we'll go to the next slide. Exhibit 5 is background. The property was subdivided in 1960, and the home on the property was built in 1961. Exhibit 6 is the variance request. The property has a required 35-foot rear setback, and the existing nonconforming home encroaches into the required rear setback approximately 14 feet. The applicant wishes to add an addition that will align with the existing home in the rear encroachment area and is requesting a variance of 15 feet to allow a 20-foot rear setback. So it's this hatched area right here. And then Exhibit 7 is the variance criteria, and I won't read them again, but all must be met. And then we'll go to 8 is considerations. Staff supports the requested variance. The 35-foot rear setback prevents the proposed addition since the rear of the home encroaches into the setback. The addition will align with the existing angled rear building line and it is an expansion of the bedroom area. Since the home is oriented towards the corner side setback along Craig, the rear yard is functionally a side yard. The established corner side yard along Craig is 26.5 feet greater than the required street side setback and reduces the permitted building area. And we'll go to the next slide. Exhibit 9 is considerations. The applicants purchased the property in 2018 in its current condition, and the home was built in 1961. The variance won't be easy to detect and will not cause public safety issues. The location for the addition will preserve the established front and corner side setbacks, which align with the streetscapes along each road. The location also ensures the preservation of several large trees in the corner side yard. You can see the trees in this photo over here. And you can kind of see the consistency of the streetscape in this photo. And then we'll go to 10. 10 is applicant photos of where the addition would be located in the yard. And then we'll go to 11, which is a photo of the property. And that's the end of my presentation if you have any questions.
April, is there anyone here in opposition? Okay, board, do you have any questions for staff?
No questions.
Okay, do I hear a motion to approve this variance request?
Move to approve the variance request.
Okay, Mr. Court,
Williamson, second.
and Williamson seconds. All right, now we go to a roll call vote. Mr. Court,
Court, yes.
Ms. Sun,
Sun, yes.
Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shay, yes.
and Dryden, yes. So the variance is approved. Now we move to the finding of facts and conclusions of law as written. Do I hear a motion to approve?
Madam Chairwoman, I would
Yes.
just draw the board to, the board's attention to item number 15. It states the zoning ordinance. Just to confirm with staff, is that meant to say zoning or is that meant to say UDO?
UDO.
Okay, thank you. So on number 15, it should read the current UDO zoning ordinance or just the UDO ordinance? UDO regulation.
I think the date of that house needs to be changed to 1961. Is that correct? House was built in 1961. To be consistent. Same one. Correct the entire state.
On 15.
Yes, it does state on item number 5 that the property was constructed in 1961.
Okay,
So on item 15, I would recommend you also change 1960 to 1961.
so number 15 will now read the non-conforming home was built in 1961 prior to the applicants purchasing the property and prior to current UDO regulations. Okay. Any other amendments before we vote? Okay, do I hear a motion to approve the finding of facts and conditions of law?
Court move to approve the findings of fact and conclusions of law based upon the revisions stated just previously.
Okay, thank you. Do I hear a second?
Williamson, second.
All right. Mr. Court,
Yes.
Ms. Sun,
Sun, yes.
Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shay, yes.
Dryden, yes. So we have approved the conditions of the finding of facts and conditions of law as amended. All right, thank you very much. All right, we will move on then to case number 2023-068. The property located at 8210 Willow Lake Court.
All right, this is a variance request for a UDO 5-foot variance from the 40-foot rear setback to bring an existing addition into compliance. And I'll give you a minute to look at your findings.
Okay, Lisa, you may continue.
All right. Exhibit 1 is a vicinity map of the property. And then Exhibit 2 is a zoning map. The property is zoned N1A, Neighborhood 1. Exhibit 3 is an aerial. And Exhibit 4 is a close-up aerial of the property. Exhibit, let's see. Exhibit 5 is background. The property was subdivided in 1978 and the home on the property was built in 1983. Exhibit 6 is more background. In 2021, an addition was built to the rear of the home without permits. In July 2023, a notice of violation was issued for the rear addition and it was not permitted. Exhibit 7 is the variance request. The applicant requests a 5-foot variance from the 40-foot rear setback for compliance of the rear addition. So it's in this hatched area right here. Exhibit 8 is the variance criteria and all must be met. Exhibit 9 is considerations. Staff supports the requested variance. Strict application of the ordinance would require a portion of the addition to be demolished. The property is located on the bulb of a cul-de-sac, so the front property line is irregular in shape and narrows in depth on the left side, which is the side of the addition. The required 40-foot front setback from the recorded plat is 13 feet greater than the 27-foot required for the district and decreases the permitted building footprint. Then Exhibit 10. Exhibit 10 is considerations. The applicant purchased the property after the addition had been constructed and state they had no knowledge of the encroachment when they purchased the property. The requested variance will not be easy to detect because there is a greenway to the rear of the property that is heavily vegetated. The home to the left is approximately 37 feet from the property line, and there's vegetation between the two homes. There is a shed located about 1 foot over the rear property line that encroaches onto the greenway property. You can see it in the survey right here. So the applicant has proposed to bring that into compliance so that they'll no longer have that encroachment onto the Mecklenburg County property. The 5-foot rear setback encroachment of the home exceeds the UDO 10% administrative adjustment allowance by just under a foot. So it almost qualifies for an administrative approval. And then Exhibit 11 is a photo of the property. And that's the end of my presentation. If you have any questions for me.
April, is anyone here in opposition? Okay, questions from the board? I have a question. Go back to that. Where is he going to just demolish the shed? Is that his?
He said he's going to move it. He's hired a,
Because I see there's a 10-foot utility easement that looks like where the shed is on the utility easement.
it is, so he's going to move it out of the utility easement and like into the compliant building
In the
footprint.
compliance footprint, okay. And that will, I mean, there'll be permits and things that they'll be pulled to make sure that happens. All
Yeah.
right, any other questions? Comments? All right, do I hear a motion to approve this case 2023-068?
Court move to approve.
Do I hear a second?
Williamson, second.
Okay, Mr. Court and Mr. Williamson. All right, Mr. Court, we'll do a roll call vote.
Court, yes.
Ms. Sun,
Sun, yes.
Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shay, yes.
Dryden, yes. So it is approved. All right, now, for the finding of facts and conditions of law. Do we see any edits we have to make? And do I hear a motion to approve finding of facts and conditions of law as written?
Court move to approve the findings of fact and conclusions of law as written.
All right, do I hear a second?
Okay, second.
All right. Mr. Shea, roll call vote.
Shay, yes.
Mr. Williamson,
Williamson, yes.
Ms. Sun,
Sun, yes.
Mr. Court,
Court, yes.
and Dryden, yes. So we have approved those.
So we can hear 7600 Harrisburg Road now.
Okay. All right, we'll go back to case 2023-053, property located at 7600 Harrisburg Road. And we should already have the finding of facts and conditions of law with attached to that. There's right. All right, Lisa, go ahead.
All right, this is a front setback variance request. The applicant is requesting a UDO 13.5-foot variance from the 27-foot front setback along Meisenheimer Road to construct a dwelling. And then I'll give you a minute to look at your findings.
Thanks.
While they're looking at their findings as the applicant for this case here. Okay.
Okay, Lisa, thank you.
All right. Exhibit number 1 is the vicinity map. And then exhibit number 2 is the zoning map. The zoning is N1B, Neighborhood 1. Exhibit number 3 is an aerial of the property. Property's on the corner here. And then exhibit number 4 is a close-up aerial. Per the definition of setback, the subject property has a 27-foot front setback located along Meisenheimer, and it's got a corner side setback located across Harrisburg. And Harrisburg Road is classified as an arterial street, so both of the setbacks on both sides of the property are 27 foot. And then Exhibit 5 is background. The property was subdivided in 1945, and the original lot width ranged from about 154 to 175 feet. Since that time, right-of-way was acquired for Harrisburg Road, which decreased the lot width by about 50%. So you kind of barely see it. It says 175 along the side there. And then Exhibit 6 is background. The applicant is requesting a 13.5-foot variance from the 27-foot front setback on Meisenheimer Road to construct a dwelling. So this is the area within the square that they're asking. Exhibit 7 is the variance criteria, and all must be met. And then Exhibit 8 is considerations. Staff supports the requested variance. The hardship results from property conditions since the width of the lot was reduced by half for acquisition of the Harrisburg right-of-way. The typical corner side setback for N1B is 13.5 feet, but since Harrisburg is an arterial, this property is required 27 feet. Future street improvements will be 33 feet from the back of curb, or approximately 20 feet of the property's width. There's also a Duke Energy easement along the left side of the property, which further decreases the building area. And then Exhibit 9 is considerations. The hardship is not the applicant's fault since they purchased the property in 2023 in its current configuration. The applicant states they were not aware of the future sidewalk when they purchased the property. The applicant's original request was to reduce the corner side setback along Harrisburg Road, but the applicant worked with staff and has agreed to change their request because of CDOT's input that they were opposed to a reduction in the setback along Harrisburg due to future road improvements. Now, with the request to reduce the setback along Meisenheimer instead, there's no safety considerations or conflicts with the future right-of-way. And then Exhibit 10 is a photo of the property. And that's the end of my presentation, if you have any questions. And we also have somebody who has signed up to speak in opposition of this case, I believe.
Then we need to move this to the regular agenda if there's someone in opposition. Is that correct?
Correct.
Okay. All right. So we will be moving this to the regular agenda. Staff, do you have, board, do you have any questions for Lisa about this?
I do.
Okay, go.
Number 6, the point, it says decrease lot width from approximately 87.5 feet to 76 and change. What that number should be what? On number 6? Because the variance, or I'm sorry, the easement or the land that was taken is in fact a road, correct?
So there has been property acquired for right-of-way, and there's also plans to acquire more right-of-way in the future. So the original plat, let me find which item you were looking at.
Direction to Harrisburg Road where they.
So let's go to the previous slide. So if you can see the side, it says it's about 175, and then that went to 87.5.
So Clear Creek Highway is now Harrisburg Road.
Yes.
Okay, so they cut the front half of that property off.
Right, so number 6 still doesn't read correctly though. So I'm just trying to get the number correct because we're gonna have to correct it here sooner or later.
So if you look at 5, that was the original width, and then it became 87 and 76. That was the range that changed.
If I'm the only one that's having a problem with this, then we can go on, but it says which decreased the lot width from approximately 87 feet to 76 feet. That's not 50%.
Oh, I see what you're saying. So it decreased the lot width from a range of approximately 87.2. Da, da, da. So I should have said it was a range. I'm sorry.
Gotcha.
I can see how that would be confusing.
So you want it to say since the time the property was subdivided, the property which decreased the lot width from a range of 87.5 to 76.37 feet, which
Correct.
is an approximate reduction of, or a reduction of approximately 50%.
Correct. Yeah.
Okay, all right. And where's the entrance, the driveway to this house? Is that off Harrisburg or is it Meisenheimer?
There's an existing, it looks like there's like a cut through, but I believe the driveway would probably be off Meisenheimer.
Meisenheimer, okay. So the address then would be Meisenheimer as opposed to Harrisburg Road. You don't
I'm
know?
not involved in the
Okay.
addressing.
Okay. Okay,
Mr. Chair, question. Can
Yes.
you please repeat the amendment?
the amendment, okay, it's going to, number 6, it's going to read, since the time the property was subdivided in 1945, right-of-way was acquired for Harrisburg Road, which decreased the lot width from a range of, instead of approximately, 87.5 to 76.37 feet, which is a reduction of approximately 50%. Mhm. Any other questions or comments for staff? All right, who is here to speak in opposition? All right,
Need to be seated at that table and
Right.
get sworn in.
and I must swear you in? So if you would please state your name and spell your last name for the court clerk.
Oh, Chanel Baskins, Baskins.
All right, and Chanel, do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth?
I swear.
Thank you. All right, you may proceed.
Okay, so to answer some of your questions that you had, my grandmother used to own the house on Meisenhammer. My aunt owns the house on Harrisburg. So the way that it doesn't make sense to, I don't see how they would get a home right there. The sign right there by itself, oh, you can go right down.
You can go to the aerial.
No, you can go down to the one, this one that has a star. So right here is the corner of it, is a sign. There is a driveway that goes into Harrisburg, but if you go down Meisenhammer, the driveway sits right here at 87.5. That's the home that is gonna be attached, like right on top of the house that's right there where a car is. So for a home to go right there, where would you put a driveway? Or where is there, they're not gonna have anything behind them. There's no room for them to have any type of yard or anything, because if you go further back, there's a tree that's right there, which goes into my aunt's yard. So it's like, where exactly would you put a house and what type of entrance would you have for that home? Because if you go down a little further, they are building they're building more walkway at the front of Harrisburg, because the school sits right behind it. I mean, like to the right of it. So they're creating a walkway from the apartments that goes up to the school. So I don't really understand where they will be putting a home. That's all I have.
Anyone have questions for the young lady?
Yeah, so the pad that they've asked for though is quite buildable. I'm ready, you're talking about the driveway being up near,
Can I walk up? Like, can I touch it?
please.
Okay. So they built apartments on this side of her home.
Yeah.
They did the walkway to stop about right here, but they're gonna continue it to go right here. And then from here, that's a home that sits right there behind where, if this is where he wants to build a house, a home sits right there. So if you created a driveway, it's gonna only probably be about right here. Because right stuff goes into the next house. And then there's no backyard for them at all, unless they're gonna build it at the top of the street. But if they're taking this right here to build a walkway, you're not gonna have a top of the street, if that makes sense.
So the
And right
pad,
here's where the community signs.
the pad they've asked for though is buildable. And you're talking about the house on the lot next door, correct?
Yes, there's
Okay.
one right here and one right
Yeah,
here.
I understand.
But they still have to figure out exactly how much of this they will be able to, because I own this back.
Got it.
And my grandmother sold hers, so.
So is the house to the north, is there driveway on the petitioner's property?
Yeah, it's actually, yeah, it is. It's like right in here. Sorry, I'm not tall enough.
No.
Right there. But, if they was to do that, then they wouldn't have a driveway at all. Because like right where this sits is a mailbox, then there's nothing for a driveway on their opposite side, if that makes sense. Thank you. But I mean, I just wanted to be able to show a visual, because on here, it looks like, oh, that's doable, but if you actually look at the property, you'll be like, okay, like, you're just gonna slap something right here on the corner, but I mean, I don't know, we just wanted to speak up about it.
Lisa, is the petitioner, are they gonna extend the sidewalk all the way down?
I'm not sure about Meisenhammer, but right here, it looks like from the way it's dug up now, it looks like they are gonna continue it out.
Yeah, CDOT has indicated that the city will be installing more sidewalk and street improvements that will come into the property. I think it was about 20 or 30 feet. I had a slide on that.
Yeah, it's shown on one of the,
Mhm.
sorry. instructions.
I think it's further. Yeah, they didn't give us building plans. They just gave us the footprint.
So it sounds like you're visualizing the grassy area as the buildable area. But in fact, a lot of their buildable area is actually part of that driveway too. They're gonna build on that driveway.
Right, so that,
And it may end up that your aunt may end up having to build a new driveway as a result of that development.
Well, not even her, but it'll be the next home, the home that's on the actual home on Meisenhammer. The only thing that will affect mine is, honest, just as long as they stay on their side,
Yeah.
that's fine. We would just have to get like a fence or something to make sure that they're not cut into hers, because it's slanted.
Yeah,
So it's like when you slant, you're going into the next home that's like literally on the left side of her.
right.
So, I mean, we say it's doable, but it's gonna look weird, you know?
okay. Any other comments? Well, I can see where it would be disconcerting for the people that own the property adjacent and have been using that vacant land for a driveway. But that's not something that we consider when we talk about this gentleman's property and what he can do with he's purchased this property. So he's not obligated to give easement to the people next door just because it's been convenient for them to use. I just want you to understand that.
Yes.
You know, that rolls into the realm of opinion. And it's not those people that are asking for easement. It's this gentleman who has bought this property, and according to this, there is enough plot for a buildable, and it may not be popular, but it is buildable within the UDO codes for him to build a dwelling there. And then it's up to the property next door to figure out what they're gonna think about with the driveway. I mean, I understand there's a mailbox, they may have to move the mailbox. I mean, there's other things that need to come into consideration for this. They might need to start planning for that if this gentleman's gonna build a house there. Okay, any other questions or comments? All right, we will now go into deliberations. So you may observe, but there will be no more discussion except by the board. Okay, comments from anybody? Ms. Sun, shall we start with you?
I think it seems like the lot is buildable if we approve the variance, and as long as it's not encroaching on the neighbors, I don't see any problem.
Okay, thank you. Mr. Court, you have comments?
I think I'm inclined to approve the variance. I understand the incongruity of seeing a vacant lot that's been historically in a neighborhood that's not very dense, all of a sudden becoming dense, and that being jarring. But I think that the facts support the use of the property and the granting of the variance.
Mr. Shea, comments?
I'm good.
Okay, Mr. Williamson?
No comment.
Okay, and I have no further comment. All right, do I have a motion to approve this variance?
Court moved to approve the variance.
Okay, do I have a second?
Shay, second.
All right, we'll do a roll call vote. Mr. Shea,
Shay, yes.
Mr. Williamson,
Williamson, yes.
Ms. Sun,
Son, yes.
Mr. Court,
Court, yes.
and Dryden, yes. So that variance is approved, and now we need to look at the conclusions of law. I'll never get that right. Do I have a motion to approve the finding of facts and conclusions of law
Court moved to approve the findings of fact and conclusions of law.
as amended with number 6?
as amended with, as amended,
That'll be fine, as amended.
correct.
Okay, do I hear a second?
Second.
Thank you, Mr. Shea. All right, Ms. Sun,
Sun, yes.
Mr. Williamson,
Williamson, yes.
Mr. Shea,
Okay, yes.
Mr. Court,
Yes.
and Dryden, yes. So the finding of facts have been approved as amended. All right, that concludes our recommendation agenda. At this time, we're going to take about a 5-minute break to kind of transition into the into the agenda, regular agenda. So give us a minute and we'll be right back. That's yours. I'm trying to make room for Wilson.
Okay.
Yeah, that's.
All right, ladies and gentlemen, we are ready to resume. And we are beginning, excuse me. We are beginning the regular agenda and we're ready to hear case 2022-077 for property located at 1108 Fairmont Street. All right, Lisa, whenever you're ready.
All right, so if you could pull staff's presentation back up. Thank you for doing that. And this will be case number 2022-077. So it should be about the fifth one. Perfect, thank you. All right, so this is a request of a UDO 14-foot variance from the 20-foot garage setback from the back of sidewalk for compliance of a garage on a duplex dwelling unit. And I'll give you a minute to look over your findings.
Okay, Lisa, thank you. You may continue.
All right. Exhibit number 1 is the vicinity map. And then exhibit number 2 is the zoning map. The property is zoned N1C, neighborhood 1. And exhibit number 3 is an aerial map of the property. The property is a corner lot. And then exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background.
Great.
There's a duplex dwelling on the property that was permitted under the zoning ordinance. For both the zoning ordinance and the UDO, there's a 20-foot garage setback, which is measured from the right-of-way or back of sidewalk, whichever is greater. And in this case, the back of sidewalk would give the greatest setback distance. So you would measure from the back of sidewalk. So here's the back of sidewalk, here's the back of the right-of-way. There's a garage on the left side of the duplex facing Fairmont, and the building permit was issued correctly, indicating the required 20-foot garage setback. And then we'll go to exhibit 6. Exhibit number 6 is the variance request. The duplex was constructed with a garage setback of 6 feet from the back of the sidewalk. The applicant is requesting a UDO variance of 14 feet for compliance of the garage. And then we'll go to 7. Exhibit 7 is the variance criteria and all must be met. And then we'll go to exhibit 8. Exhibit 8 is considerations. The home was not constructed as permitted, but the applicants purchased the property in November 2022 after it was constructed. The hardship doesn't result from conditions peculiar to the property since the home could have been constructed in compliance. Portions of Fairmont Street and sidewalk encroach onto the subject property, but the street and sidewalk existed prior to the permitting and construction of the duplex. And you can see the street and sidewalk on this 2017 aerial photo. And then we'll go to Exhibit 9, Considerations. There's a compliant 20-foot-long driveway for the use of this side of the duplex and provides required parking for the duplex unit. So here's the compliant driveway. If the variance is not granted, the structure would not have to be demolished because it's compliant with the minimum 10-foot corner side setback for a home, which is measured from the property line, which is, so it's 10, they've got the 10-foot they need for the structure. They just don't have the 20-foot that they need for a garage. So they could repurpose the garage and it could be compliant. Granting the requested variance would not uphold public safety because the minimum 20-foot setback ensures visibility and pedestrian safety and provides parking and maneuvering area so vehicles are not parked on sidewalks. And so we can go to the next slide. Exhibit 10 is considerations. The Charlotte Department of Transportation does not support a variance for a driveway garage connection that encroaches into the site triangle. And then Exhibit 11 is a photo of the property. And that's the end of my presentation. If you have any questions, and we also have the applicants here.
Okay.
The case where the surveyor says mistake. Only says the surveyor mistake.
Yeah.
Yes.
Any other questions for staff?
Did the surveyor acknowledge their mistake?
At this point, I would,
We'll get into that.
at this point, I would advise the board to wait for the applicant's presentation and until their witnesses are sworn in to ask them any questions.
Any other questions of staff? All right, the applicant is here, and so if you will please state your name and spell your last name, please, and then we will swear you in.
Members of the board, David Murray, I'm here. This is a LLC that's an owner, so they have to be represented by counsel. So it's DRW Ventures. My client's out of Florida. Today with me, I have the builder, John Gallardi.
Could you spell his last name, please?
You can introduce yourself.
John Gallardi, Hallmark Building, Gallarde.
Russell Klaus, Cardinal Surveying, CLAUS.
We don't need to be sworn.
Yes, you do. All right, you may all affirm, do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Yes.
Okay, all right. All right.
Members of the board, again, David Murray, Murray Law Firm here on behalf of the property owner. This is a 14-foot variance from a 20-foot garage setback, which is a little bit different than the setback for the actual structure. We're not here for a setback on the structure. It's just the garage door face. So there was a lot that took place here. So I'm going to go through that, and that's why I also have the builder and the surveyor here, because there were a lot of things that rolled, and this just snowballed until we got to where we are today. But my client purchased the property in November 18, 2022. I have an affidavit from my client that we'll go through here in a second. So when the builder started, there was an initial site survey that showed the correct side yard setback of 20 feet. That's what the permit shows. The building permits show the building setbacks. They don't show a garage door setback because that doesn't come up that often. But again, it's not shown on the permit. So staff said the 20-foot garage door setback was shown on the permit. That's not correct. That was the 20-foot setback from the structure. So the survey showed that the sidewalk was constructed outside of the city's sidewalk easement. Then that survey was provided to the architect home designer who placed the structure on the survey to show Russell, who is the foundation surveyor, to show him where the buildable area was on this site and how this structure would sit on the surveyed site. So that design was sent to the city and the permit was issued. However, in city permitting, they missed the fact that there was a side load garage on the property. So they issued the permit, but they missed the fact that there was a garage door setback, and that garage door was set back 11 feet from the back of the sidewalk. And again, that sidewalk wasn't in the city's easement, it was into the property some. So then that design survey was provided to Mr. Klaus, who was the staking surveyor. And unfortunately, he made a further mistake and put the foundation stakes 5 feet closer to the street than should have been. So we're supposed to be 20 feet back on the garage. As the plan that was submitted was approved, we were encroaching 9 feet. And then unfortunately, because of the stakes that were put down for where the foundation was built, there was an additional 5 feet of encroachment. So that's why we are now here with a structure that's built with a garage door 6 feet from the back of the sidewalk. The builder relied upon those stakes. They're placed in the ground, they were constructed. As I will show you, the city code enforcement conducted at least 20 inspections of this site, and no one ever found that there was an issue. The as-built survey was submitted showing that this was a condo. It actually identified violation of the setbacks, and the city reviewed it and approved as a condominium plan. So this was the plan that was submitted. We have the surveyor marker. This is slide number 4, which shows the survey without the structure. This is it's hard to zoom in on these plans. You can really zoom them in really closely on the CAD drawings that were submitted to permitting. But this was the plan that was submitted into permitting. And here it is zoomed in, and the red marker here is showing to the face of the garage door that's the distance between the actual back of the sidewalk, which again is outside of the sidewalk easement, which again is beyond the right-of-way here because the right-of-way actually goes into the street. And so this was the plan that was submitted and permitted. The structure itself at the time was showing to be in compliance with the 20-foot side yard, but the garage door itself was encroaching closer. This was the plan that was submitted. It showed a garage door. This was the elevation. It says Fairmont front elevation. There's nothing hidden here. These plans were submitted showing that there was going to be a garage door. This is this slide is slide number 8, which is the slide showing the Mecklenburg County permit office records showing that there were 20 inspections just on the building permit. There were also electrical, mechanical, plumbing, and that the occupancy final inspection was done. The certificate of compliance was granted. This is slide number 9. And then a certificate of occupancy was granted on slide number 10. And that was granted on September 30th of 2022. This is an aerial picture. It's a little blurry on here. I'm not sure why, but this is an aerial picture. So ultimately, when the setback issue was discovered, the builder in order to bring compliance to the 20-foot driveway that was needed in order to have vehicle parking, constructed this adjacent pad here that measures 20 feet to the back of the sidewalk. So there's compliance on that parking pad. The main issue here is if this garage door is sealed off, that is taking away another parking spot. So right now, this garage is actually used for a vehicle to park. And so if this is sealed off now, the only place to park will be in the front, because if you're parking here, you're parking over the sidewalk. And my clients have instructed the tenants, there's two tenants, one on one side, one on the other, since it's duplex, not to park in front of this garage. Here's a picture. This is showing the compliant parking area. This is showing the setback to the garage. As you can see, there's a planing strip between the street and the sidewalk, and then this sidewalk is actually beyond the city's sidewalk easement. This would be looking up Fairmont, heading north. This over here that says do not enter, there's a driveway that's across, but it says do not enter. That's actually CMPD. There's a police station basically across the street here, but they don't use that as an entrance into the property. This is an aerial that I think is important to see what the surrounding uses are for where this garage faces. This is the police station here, the CMPD, and this is the exit that's a do not enter from Fairmont. You can see there's no other driveways there. There's like a gravel entrance here, but the main entrances to these, I believe they're car, automotive kind of repair businesses. This is the city's, this is Beatty's Ford Drive. This is the city's large water treatment facility that's diagonally from this property. And then here's some residential going east on Oak Lawn Avenue. But the way that this garage faces is facing open gravel lot for automotive use, CMPD, and then a water treatment facility. There's not a lot of foot traffic is the whole point here. This is a picture of the treatment facility that's diagonal. This is a picture of the intersection. As you can see, the street, and then this is the driveway into the property. It would be on the right side of the slide next to the yellow sign. So again, how do we get here? Well, the closing attorney that represented the buyer and the builder had concerns because of a recent case that came out of Mecklenburg County that if you had a zoning violation, that you might not have good title to your property, that the zoning violation would result in a marketable title issue. No notice of violations ever been issued with the city, as is very obvious here. The whole process, there was a lot of confusion throughout this process, but the variance was voluntarily sought to alleviate the setback issue, and nobody ever noticed this. So kind of my knee-jerk reaction when I saw this was, why didn't y'all just wait 5 years for the statute of limitation to run, and then this wouldn't be a problem? But regardless, we're here asking for the variance because the closing attorney wanted to submit it in order to make sure there was good title. This was the affidavit from my client who couldn't be here today, but I want to make sure there was a sworn statement. And again, he was advised by his closing attorney the proper permits have been obtained, that the property passed the inspection, structure had been issued, certificate of occupancy notice of violation been issued. And unfortunately, the UDO did not resolve the 20-foot garage door setback that existed on the property. So that's why we're here. Mr. Klaus is a licensed surveyor who's here with us today. Mr. Klaus, can you confirm, this is slide number 19. Can you confirm that this is your testimony here today, in your opinion, that the builder relied upon your survey in good faith and did not know about an issue?
Give me a second to read it here. Yes.
Thank you. Members of the board, do you have any questions for Mr. Klaus here?
So who actually put the stakes in the ground?
My guys.
And so you adopt slide 19 as if it's your testimony here.
That's correct.
This is the condo plat that was submitted for approval and recording for this duplex. And as you can see here, what's interesting about it is it shows actually that there's a violation. The UDO changed the side yard setback here. So originally it was 20 feet, now it's 10. But unfortunately, it didn't change the garage door setback. So the garage door setback under the UDO didn't change. But what's interesting is this went through condo approval and it was actually showing the encroachment and it didn't get flagged. Again, the builder here, Mr. Gallardi from Hallmark Builders, it was his attorney that originally submitted this variance. And then I took over for the property owner. But Mr. Gallardi, can you confirm that everything that's shown on slide 22 is correct for your testimony here today?
Yes, that's correct.
Thank you. And just confirm you relied in good faith upon the surveyors and design plans, and you had no knowledge of this garage setback standard when you built the house?
No, no.
Thank you. One other thing I'll point out here, because the structure was shifted over, they actually didn't build the house or the duplex any bigger than it would have been, because they designed it to fit the building footprint and then it just shifted over. So they didn't get any benefit from this encroachment. Oh, and Mr. Gallardi, you can confirm that the city engineer did actually come out and inspect that driveway and approve it from the garage, correct?
Yes,
You can talk toward.
we had the building final, city engineering final, approval, condo plat approval and recorded. And, it was a voluntary, like David said, it was voluntarily done because of the closing attorney from the buyers.
And has CDOT, the staff mentioned CDOT. I have never heard anything from CDOT prior to this hearing today. Have you ever heard anything from CDOT?
No, haven't. And the site triangle, I don't know where it falls over there, because that's the first time I heard about it.
Yeah, and members of the board, and for the record, we object to anything that was submitted that purported to be from CDOT as hearsay. So here we are. So the variance standards, again, the board shall vary upon a showing of all of the following: unnecessary hardship, conditions peculiar to the property, did not result from actions taken by the applicant, and that the variance is consistent with spirit, purpose, and intent of zoning ordinance such that public safety is secured. I think that's probably supposed to be UDO now. So again, it's necessary because if the variance is denied, the garage will have to be sealed off, which eliminates a further parking area on this property. So staff is not in support of the variance, but they want to seal the garage, which is going to further exacerbate the parking problems at that site. So the variance is to solve a problem with the fact that during the permit process, this wasn't caught. And then it was further exacerbated by the fact that the surveyor made a mistake. Unnecessary hardship here, as I just covered, is it would eliminate the use of the existing garage. The renovations would cause, substantial impact. One thing I note is in the affidavit from my client, the long-term tenant is actually using this garage for parking. And so they've been instructed not to park in front of the garage, but they're actually using it. So the tenant would have a use that would be eliminated from what they believe that they would have a right to use. The hardship runs with the land. There's a bunch of different peculiarities about this property. That there was a pre-existing sidewalk located on the property that was not in the city's easement. The sidewalk here is actually not in the right of way. Most of the time you see the sidewalks in the right of way. It's also set back from the right of way. In addition, the property line runs into the street. So this corner this is an old street that was platted out generations ago where there's never been a right of way taking. As you could see in the pictures, there's no sidewalk that goes down at the corner because there's never been any city changes or any improvements there. So when you're surveying the right of way line, the right of way goes into the street. There's supposed to be an easement. Well, the easement doesn't match up with the sidewalk. So we have those two initial peculiarities about the property. Then we have the additional issue that there was a permit issued. The plans were reviewed, didn't find the setback. Then there was the surveyor error. And then one other kind of interesting thing about Fairmont Street is when it gets to the curve, it slightly swings in. So the property line swings in a little bit at the intersection. And then obviously the hardship that we have is this existing permitted structure continues to exist there. So the structure itself is peculiar given the circumstances. No self-created hardship. The act of purchasing property with knowledge may not justify or be regarded as a self-created hardship. This was not the property owner's fault, and it was not the builder's fault. So I cited two cases that I believe most members of the board here that you've seen before in the past. North Carolina Court of Appeals has found that when there's reliance upon a survey in good faith, that can present grounds for granting a variance. And the North Carolina Supreme Court has said that when a permit is issued and it's improperly issued, the government can't be stopped from enforcing its ordinance, but it does cause a hardship to the property owner because they built in reliance upon this permit. Again, if the variance is denied, the public won't benefit in any way. There's no evidence here of any safety issues. Staff reference CDOT, but again, CDOT's never even spoken to us. They never even came to us before this hearing. This is all new that we haven't even heard about for today. And again, like I said, we're objecting to that because there's no one here to testify for CDOT. But the city and the county conducted multiple inspections here. The city engineer came out and looked at those driveways and permitted it. And there's never been any issues with any safety problems that I'm aware of through my tenant, through the client, or through the builder here. And when we look at the intent of the ordinance, I just pulled out a couple sections of the zoning ordinance. I thought what was interesting is it never specifically says, why do we have to have this 20-foot driveway setback, until actually when you see in the UDO, they finally clarify to allow a driveway of parking pad to meet the 20-foot width. So the idea is typically when you have a garage that's a side load garage, you don't have, like in our situation, where you have another parking pad next to it. Typically the side load garage is the parking area. And so the city's just trying to make sure that there's enough space to park another vehicle in front of that garage. Well, here we've provided the adjacent 20-foot parking pad, so we don't have to park in front of that garage. Fortunately, we were able to have space to do that. So we weren't stuck by the construction itself. Here's a picture of the 20-foot parking pad. That's John's car parked in front. That's not someone else parking there for picture. And then one other interesting side benefit here was, because it was shifted over, these these trees actually ended up being preserved instead of being torn down on the property. And so these, I think they call them heritage trees. We had to do a little trimming, but they were not cut down as a result. If it would have been permitted properly, those trees would have been gone. So again, the four standards entitling us to the variance have been met. If you have any questions, we are happy to answer those builders here, surveyors here, and I can answer on behalf of the property owner. Oh, and I also have some proposed findings and conclusions of law that I would support, that I would submit.
While he's passing it out, board, do you have any questions that you would like to ask?
So I'm just, so we're all on the same page here, if you could help us, please. A building inspector, mechanical, plumbing, building, electrical, they're not zoning inspectors. They are literally building inspectors that look at the quality of the building, does it meet the code?
Does he need to be sworn in?
Swearing.
Oh, swear you in? Okay, sure. Okay, Mr. Solomon, do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth? So help you
Can I
God.
go ahead and swear in for the rest of the hearing?
Yes, sir. You may swear in for the rest of the hearing. Thank you.
That's correct, Kevin. So when he mentions that, when David mentions the citywide inspection, it was like city engineering, and then it's Mecklenburg County Building Code, which they are not looking for zoning ordinance requirements. They are looking for the apron that ties into that public right of way, and then any sidewalk, if they have to do any repairs to that sidewalk, that's part of that permit.
Thank you.
Mr. Fortune, there was a zoning inspection that was completed here and it was passed. Isn't that correct?
Not to my knowledge.
Why wasn't it? There was a certificate of occupancy that was issued and all the permits were issued. And so that would be an admission on the city if they didn't do it. I'm pretty sure they did it though.
So typically what happens is the city looks at that stuff when you guys submit, when applicants for a single family home submit the permits, they are looking at it through all the surveys and when they do the as-built, and that's sometimes, and that's how they are releasing their CO.
But the city building permit standards say that zoning approval was given.
We approved it as part of your permit submitting for a single family home. We would have reviewed it as part of that building process in Mecklenburg County.
So just for clarity, zoning approval was provided.
Correct, based off of the information that was provided to the reviewers.
Yeah, showing a 20-foot left side setback.
Is there any, are there sidewalks in the street? Besides in front of your place, are there sidewalks in these streets? Can I see an aerial?
Well, here's the front. There's the side. Let me see. Yeah, here's the area. Sidewalk along Oak Lawn and up Fairmont. CMPD has a sidewalk. Then there's a sidewalk across Oak Lawn going by the water treatment facility. But at this corner, I believe it's only on the front. At the corner of Fairmont and Oak Lawn to the northeast, it's on the frontage.
Thank you.
Mr. Klaus, I'm interested in how did you communicate to whoever put the stakes in the ground where they were supposed to be? Did they have a plot design? Did they have measurements? How did they decide where to put the stakes? You said you didn't do it personally, your people did. How did your people know where to put the stakes?
I had put a plot plan together for my crew. I had put that together incorrectly. So the crew stake that we're at calculated, I made the mistake.
Okay. And you're just finding out about it now that this has all come up. You didn't know that you'd made a
I literally
mistake.
did not know about it until we submitted the condo plat like 4 days before closing. And then it got rejected because the building didn't meet setback. And I'm like, oh, wow.
Interesting. And yet everybody relied on you to do it. And we're here because you didn't do it right. And and now you're asking for forgiveness because you made a mistake. it worries me. I hope other people that have hired you don't come to us with similar problems.
I would hope not.
Can I see another picture of the building? Looks like the south view. All right, so the driveway, okay, so trying to find, I feel for you guys. I might just feel for you. This stuff happens. I'm a GC. I understand it happens. And I'm looking for a solution for you besides a zoning or an ordinance issue. Have you looked at putting a parallel driveway in to unit number 2 and doing a shed dormer on top of a new garage that points 90 degrees the other way? Have you looked at that option? Do you understand what I'm saying?
Can we, I don't even know that we can get a driveway. We have to have separate driveways. I don't think we can.
Understood. I see the driveway for unit 2. So for the driveway, for the unit you're talking about now, if you came in this way, you don't have enough room for a full roof line, but maybe a shed line would work. Have you looked at that as a solution?
From the south, we can't do that because we gotta have separate.
I see a separate driveway, but you got 2 different.
West.
Yeah, I'm looking at your survey and the survey has a single driveway. The one we're looking at in the far, yeah, that right there in the back of that picture.
This is going north, so the left is.
That's right. So why not put another northbound driveway in?
I think we have to have 2 for duplex, right?
That's what I'm saying.
It would be
2.
a separate driveway.
It would be a separate driveway.
What I'm saying is, the problem is when we're at the corner, we can't put in another driveway.
Why not?
Because we're too close to the corner. This driveway is at the spacing, for that.
How did? So your stake went down 5 feet. It was,
Closer to Fairmont.
Towards Fairmont.
Thank you.
and does that mean the whole building shifted both?
Yeah, that's correct.
Shifted
It was
over?
the whole building just got block shifted closer. to
So
Fairmont.
it wasn't a situation where we got 5 more width. It's just the whole building shifted.
Did that end up, did that avoid a tree save problem?
No. It didn't avoid anything. It was just a mistake.
It was just a mistake. Didn't know about it until after the building was built.
All I was pointing out was the irony was that the heritage trees ended up being preserved because it shifted over. But that wasn't why it was done.
Just luck.
It looks like it resulted in a larger backyard for one condo owner, and maybe a more equal square footage of outdoor space for the 2 condos. It is what resulted. I'm not saying anything about a tent, but that's just what resulted.
And another thing is, so you moved the stake, shifted the house 5 feet away, but why is there a 14 feet encroachment?
Because, so when the house was submitted, the builder did not realize of the 20-foot garage door setback. They submitted the house at the 20-foot setback. But it's confusing, but the garage, so the garage door was, no, the setback was 10 feet, the setback's 10 feet, setback's 10 feet. But the garage door can't be 10 feet, it has to be 20 feet. So it just,
If the building had been built according to the submitted plans, the building would still be
there would still be a,
violation of 9.
that's right. That's the way I'm trying to say it. The survey further exacerbated this. That's why I said, starting at the beginning, this just snowballed. So it's like the plan was submitted, but the garage door setback was not correct. But that went through all the approval process. Nobody ever caught it. But then when they went to actually build, unfortunately, the surveyor put the stakes in the ground even closer and create even further of an encroachment.
So we're not here because of the surveyor.
And so now,
necessarily.
so we're here for two things. We're here for the permitting and we're here for the surveyor. And now my client, the owner, who has a tenant in here, is asking for the variance.
So even, so if the surveyor did everything correctly, there would still be a 9-foot.
If the surveyor did everything correctly, we would still have to be here asking for a variance because of the whole permitting process that went through.
Well, who made the mistake? Is it the designer or
The designer.
builder?
The design engineer, the design architect.
And nobody on the owner's side or the builder's side ever caught this?
To our knowledge, no. Until the closing attorney had it, and then the closing attorney said, look, I think Suzanne Todd was originally the attorney that was involved in this. And then the builder reached out to me and said, look, we have a problem here. The closing attorney brought up this issue. And so it's multiple levels of error.
Mr. Murray, is this a rental property or is this?
It is. There's two tenants in there.
So the owner in Florida just bought it as an investment?
The owner in Florida bought it as an investment in reliance upon the closing attorney who said, hey, no issue. But again, that doesn't, you can't hold that against them for the variance.
What is the current distance of from the back of sidewalk to the garage?
That's the variance that we're
What's
asking
that
for.
number?
6.
It's 6 feet?
Mhm. That's from the back of the sidewalk. So the measurement is not from the back of the right of way. It's it's just from the back of the sidewalk.
Right, yeah.
Or even the sidewalk easement. The sidewalk easement's further, but
So could you move the sidewalk and
unfortunately, we'd still have to be here. I can tell you, we've stared at this thing, or at least I've stared at this thing.
Sorry, you can move the sidewalk and make that number less than the 6 feet, but you couldn't make the problem go away.
But then the sidewalk, you get rid of the planting strip and then the sidewalk's right on the street. It doesn't solve enough problems for us not to be here.
And the people who rent this, they can't park just in the drive. They have to either park on the pad.
They park in the garage and on the pad.
Park in front of the garage.
That's right.
And they're aware of it.
Oh, yeah, it's in my client's affidavit. They've advised them, do not park. Shoot. Owner is instructed not to park in front of the garage door, park on the parking pad that was acted next to the driveway.
And I think the intent of the code is that it's human nature or custom, local custom to park in front of a garage. And the city can enact ordinances to outlaw the action, but the custom will continue, and therefore, and I think this is despite their attempts to grant more density and encourage more housing options and everything, they realize that they have to provide this 20 feet to combat the human nature of people who live around here. We're not a mountainside in Italy. We park the car in front of the garage.
My question always was, okay, what if it was a 30-foot sidewalk and you park 2 cars there? It's the same thing. I mean, you could have a 100-foot driveway. I mean, not 30-foot sidewalk, 30-foot driveway, but if you have a 100-foot driveway, somebody can still park across the sidewalk. I mean, it makes common sense not to park there. I know there's we did a pre-submittal for a project one time, and I think there's some code that says you have to have less than 7 foot of driveway or 20 foot of driveway. So you have less than 7 foot of driveway, so nobody will park behind the garage door, but in this case, it's different, so.
WUR.
Yeah, I don't,
The old
I can't remember
UR
exactly
less
what
than
it was.
40.
It's been a few years.
But again, here, I can tell you the evidence is the people are not parking in front of that. They're parking, sorry, in front of the garage. Parking in the garage is empty. This is not being used for storage. You can look in the windows right now, they park in it. And then if they have a second vehicle, they park in front. In that one picture about them parking out on the street, one picture of the vehicle, that was John's car because he was taking a picture.
But I mean, we can't foresee the future. I mean, these people are not possibly gonna live in this house forever. And the next people may not use it they use it for storage, then they're parking on that pad and they're parking in front of that garage. I would guarantee you they will do that. Because like.
I totally understand, but there's not
And I
testimony.
understand. I mean, it's a really tough thing. And I'd like to grant every exception, but every time we grant an exception, then the next person who comes along is gonna be a Mr. Klaus who says, oh, I made a mistake. Fix it for me. I don't. You have a parking pad. You do have the option, unfortunately, of closing off that garage door, sealing it. So if it's extra living space, then for the people who live there, they just have to park on the parking pad. I just.
The garage was built as a garage. It's not a finished space. It's not very wide. It's not a double garage. So it's not a space that converts easily to living.
You can still you can park inside your house, can't you? I mean, if the garage was heated, they could still park in there.
I would advise the board at this point to consider if there are any questions that have not been answered at the time by the applicant. I'm not sure if there's any additional witnesses that the board needs to hear from, but I would advise you all to consider if there are any additional questions that the applicant and their witnesses need to answer before they end their presentation.
I have one final question then for the builder. I just want to make sure I'm crystal clear about this. You have looked, or have you looked at solving this problem in another way besides getting a variance?
Well, we put the extra parking pad out there to allow for 2 off-street parking spaces. There's, other than closing off the garage door and only leaving 1 parking pad, I mean, I don't know what to do. I mean, as I said, we could heat the space and call it heated living space with a roll-up door and they can still park in there. I mean, I don't think there's any ordinance that says you can't park inside your house. That's all I can figure out.
Just,
You know, I
the
mean,
answer to my
it was,
question,
yeah.
the answer to my question then is no. You
Correct.
do not have another solution that you can look at.
No, we don't.
On the garage
no,
access.
We don't have any.
All right, any other questions? All right,
Madam Chair,
Yes.
I just had a question actually for staff. Is there a certain number, how many parking spaces are guaranteed per unit? And this place, a duplex?
So it's 1.5 spaces required per unit in the UDO. And they have the 20-foot driveway shown here that they can utilize. There's also been on-street parking along Fairmont Avenue whenever I've gone to post the signs, because this has been continued several times. So the times I've been out there, there has been on-street parking as well.
And also, I'd just like to address the comment about CDOT's, I guess, opinion being hearsay. And of course, you know that the board can receive hearsay information. It just has to be given limited weight.
Thank you, Ms. Hagelgrave.
And I'd like to do one final follow-up whenever.
Excuse me?
I'd like to do one final follow-up.
Yes, ma'am, you may.
Okay, if you're looking at this picture here, so the building itself is compliant with that side yard setback. It's just the use as a garage that's making this non-compliant. So if they repurpose the garage to another use, it would come into compliance and they would still have that driveway and on-street parking. So that's all I wanted to say.
All right, any other comments or questions? All right, the board will move into deliberations. You may listen quietly as we decide.
Madam Chairwoman, have you asked if there's any witnesses in opposition or in favor to be heard on this case?
Thank you. Were there, April, anyone else that wanted to speak? Okay, thank you.
And just, Madam Chairwoman, as you start your deliberations, I would advise the board again to consider the facts as they relate to the variance standards and to relay once more in your quasi judicial capacity, you are to determine the admissibility and the weight of evidence as presented. I know there's been commentary about hearsay evidence. You, again, as you read originally in the initial script, hearsay evidence might not be entirely excluded. However, it might be given limited weight, and it is your duty as a board to determine what, if any, weight and what, if any, admissibility that evidence might have.
Comments? Anyone?
My only frustration is that it's permitted and approved and built and inspected and passed. It's so I'm sort of inclined to approve the variance based on all the check marks that they got during the process along the way. But at the same time, I understand staff's position on it doesn't have to be torn down if the garage is repurposed. So I'm looking for comments either way on those two.
I agree with you. My only concern is the safety of, I think everybody's right. Someone's gonna park in that garage, in that driveway right there and cause a problem. That's the only concern. I mean, I really want to approve, but I have a real problem with that safety issue, I think.
If we don't approve the variance, is that what you're talking about?
If we do approve it, the only concern I would have would be the safety of somebody parking there, blocking the sidewalk.
Right.
I think staff has a legitimate concern here.
And just members of the board, just to be clear, I would advise you all to limit your considerations to the testimony that you've heard both from staff and the applicant.
Well, let's look at our criteria. Unnecessary hardship would result from the strict application of the ordinance. It would be a hardship. I don't know if it was unnecessary if they had to close off the garage. The hardship does result from condition, or does it result from conditions that are peculiar to the property? Not necessarily. It's because there was an error. The hardship, I mean, it wasn't taken necessarily by the applicant or the property owner. The owner bought it after it was built. Is the variance consistent with the spirit, purpose, and intent of the UDO? And it says in that the public safety is secured and substantial justice is achieved. I have some real concerns about this request.
Madam Chair,
Yes.
I'm gonna make a suggestion, just gonna make it, this is a general suggestion. Can we delay 30 days? I'd like to look at this more. I just think I think these guys are in a bad spot. I think there's some days 1,000 ways too, but I doubt, or I think there's a possibility of solving this problem that makes it really happen. And I think we had 30 days to chew on it a little bit. We might be able to do something.
Do I hear a second for that request to delay 30 days from anyone?
I'll second that.
Okay. All right, let's take a roll call vote. Ms. Sun, would you vote to delay 30 days?
Sun, yes.
Mr. Court,
Or yes.
Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shay, yes.
Dryden, no. But it passes, so, applicants, we will, I don't know how it works. We'll come back to this in 30 days at the next meeting.
So it sounds like the board has voted to delay making its final decision for 30 days. And so at this point, we would encourage staff to put this back on the agenda for the next month in October. And at that point, the board should render a decision on this particular case.
I don't believe we're interested in hearing your presentation again, Mr. Murray. Okay.
I can't talk more, but we need to research that issue, spend back more information to the board.
So generally speaking, it sounds like the board has concluded its deliberation, and at this point, they are just taking the time to reconsider the evidence that has been submitted. And the purpose of the delayance would be to consider that evidence and then come to a conclusion at the next meeting. I don't believe that the board voted to hear any additional evidence at this point.
Okay, Mr. Shea, are you satisfied with that?
More or less.
Okay. All right, so we will delay this decision for 30 days. I apologize. We could not come to render a decision today, but we will have something for you in 30 days at the next meeting. Thank you for your presentations. Thank you for being here. Ladies and gentlemen, we're going to take another quick 5-minute break before we hear our last agenda item for today.
Dave will wear you out, man.
Ladies and gentlemen, we're ready to resume, and our chair is now with us, so Douglas Wilson will take over this meeting. So we are reconvened for our last regular agenda item appeal. Case number 2023-065, the property located at 3107 and 3103 Crosby Place. Crosby, I apologize.
Still morning. All right. Good morning, everybody. Morning. All right, so I'm going to go ahead and start it. I swear to man.
So for
Yeah.
this next item, I'll be presenting along with Laura Harmon. And Laura, I'll let you introduce yourself.
Yeah.
Oh, and she needs to be sworn in.
Morning. Yeah. So what I'll do is, if you could, is there a Bible up there? Okay. All right. And if you can just state your name for the court reporter.
I'm Laura Harmon.
Okay. And Laura, do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth? Thank you very much. And just to make sure we have everybody sworn in, I'd like to also swear in the applicants up here. Well, if you can just put your hand on the Bible. Okay, sorry, okay. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, nothing but the truth? Thank you very much.
State their name and spell their last name.
Yeah. They have the court, Candy, do you have their names? Okay, if you can, for the court reporter, just give your name
Spell it. Last
and spell it.
Chad Spencer.
Allie Davidson, ALI.
You ready? Okay.
All right, and I'd like to have Laura to introduce herself.
Sure. I'm Laura Harmon with the Planning, Design, and Development Department and have been the Unified Development Ordinance or UDO project manager.
Right.
She has been involved the whole time in the creation and writing of the UDO. All right. Exhibit number 1 is a vicinity map. Exhibit number 2 is a zoning map. The property is zoned N1B. Exhibit number 3 is an aerial map of the property. So you can see that the lot's kind of located on a corner of Cosby and Arnold. Exhibit 4 is a close-up aerial map of the property. And then Laura, exhibit 5.
So Exhibit 5 is background. As you're hearing this appeal, you'll hear that there are 2 different standards that are related to this appeal. They function independent of each other, but are both are germane to what you're discussing. One is the building height, which is shown on the left. It is measured from the average grade to the top of the building. And the second is the sidewall height, which is on the right. And those are the side walls as you're facing a residential structure, the side walls of the building. The UDO allows duplexes and triplexes in all established neighborhoods. So the sidewall height is an entirely new concept to the UDO and is designed to manage height and scale of these buildings as they're being allowed to be built in our established neighborhoods throughout the city. The sidewall is measured from the structure's finished floor elevation of the main floor to the eave, or if there is no eave, to the bottom of the roof plane. Exhibit 6 is additional background showing the building height, how it is determined, as well as the maximum building height for the different neighborhood 1 zoning districts. And you can see, see if I can do this. You can see the building height being measured from here to the top of the building. Exhibit 7 are considerations. I'm talking first about the Neighborhood 1 zoning districts. The intent of these districts is to respect the character and development pattern of Charlotte's established residential neighborhoods when we are dealing with an already built environment, and also to allow for the development of single family and the new duplex and triplex in these neighborhoods. The specific standards within each of the zoning districts address the building form and are designed to promote context-sensitive, compatible neighborhood development. This is the zoning that you will find in most of our residential neighborhoods, virtually all of them. Moving on to Exhibit 8, additional background. The duplexes and triplexes in our N1 zoning districts meet additional regulations beyond the standard building height. So all duplex and triplex buildings are limited to a sidewall height of 20 or the average height of the residential building sidewalls on both sides of the lot, whichever is greater. If the sidewall height of greater than 20 feet is proposed, a height survey of the closest residential building sidewalls is required. Additional building height is granted at a ratio of 1 foot movement from the side setback, giving you 1 foot of additional height for the roof structure, including dormers and gables above the eaves for the duplexes and triplexes. And so that is the point of that building height setback plane, is to give you the height limitations, allowances for your roof structure. Again, the regulations do not, with respect to sidewall, provide any way to increase the sidewall height over 20 feet other than what is found in subsection A, which is the averaging of your abutting sidewalls. Subsection A is independent of subsection C and vice versa. We move on to Exhibit 9. This is a graphic from the UDO. It shows, again, you can see circled in red, that the maximum allowed sidewall height is 20 feet, or the average of the adjacent buildings, whichever is greater. It does not talk about any additional option to increase your sidewall height. The example residential building on that graphic shows that only the roof, including the dormers and gable ends, are allowed to be above the defined maximum sidewall height, even though that building is further in than the required side setback. Yeah.
All right, so we wanted to give you a visualization of what different sidewall heights might look like typically. And so this is an example where the sidewall is approximately about 9 foot. And that would be like a modern ranch home, like a 1-story typically. So then Exhibit 11. So this is an example of a home that has a 20-foot sidewall height on one side, and you can see it over here. So that's going to be about a 2-story home. And in the N1 districts, the 20-foot is the standard for the sidewall height, unless you have that survey that the 2 adjacent properties average is greater, then you can increase it. So this would be typically what we're looking for as the maximum sidewall height. And then Exhibit 12 is an example of a home with approximately a 30-foot sidewall height. So that's going to be probably a 3-story typically. And then Exhibit 13 is background. The applicant submitted a sketch plan for the property showing the sidewall height of 32 feet, and that exceeds the 20-foot maximum sidewall height by 12 feet. The reviewer that reviewed the plan commented that the maximum sidewall height is 20 feet. So this would, as we looked at those examples, 32 feet, probably about a 3-story building. And then next slide. Exhibit 14 is background. The UDO allows an increase of sidewall heights of the average of the 2 adjacent properties if their sidewall heights exceed 20 feet. The applicant is not eligible to increase the sidewall height with this provision because the adjacent properties are 1-story homes with a sidewall height of probably about 9 to 12 feet. So the white home is on the subject property and that's been demolished. And so the brick home is the neighboring home on Cosby Place. And then next slide. The neighboring home on Arnold Drive is also 1-story. And then next slide. This top picture shows the homes directly across the subject property on Cosby Place. And then the bottom shows the home across on Arnold Drive. And because of the bend in the road, you can't really see the other homes along that road. And the next slide. The maximum 20-foot sidewall height is only for duplexes and triplexes subject to the N1 zoning district regulations. So some examples of other neighborhoods zoned N1 would be the Belmont neighborhood on top and the Cherry neighborhood on the bottom. Next slide. And then some other neighborhoods, we have Wesley Heights on top, and you can see a 2-story home on that street. And a newer subdivision that was approved in 2020, so the homes have been built since that time, on Lady Fern Circle. And there you're starting to see with the more modern subdivisions about 2 stories. So then next slide. So the applicant is appealing the zoning administrator's determination that the sidewall height cannot be increased due to the language in the Unified Development Ordinance. Article 2 has 2 separate definitions for building height and sidewall, which are independent of each other. And Article 4.3D1 and the building setback plane drawing labels show the sidewall height as the maximum height of 20 feet or the average height of adjacent building sidewalls, whichever is greater. The sidewall height provides flexibility of building design while maintaining appropriate transitions to adjacent surrounding land uses. The applicant's appeal for duplex and triplex dwellings in the neighborhood 1 zoning district, applicant contends that the 20-foot maximum sidewall height only applies at the required minimum side setback. And next slide.
So Exhibit 20 is considerations. A little bit of background on how we got to where we are now. Charlotte's 2040 comprehensive plan identified 10 place types, each of which identified the desired type of development for properties classified under the applicable place type. And one of those place types is the neighborhood 1 or N1 place type. This is the area where we have our lower density housing, and it allows single family duplex and triplex dwellings on all lots. The UDO developed neighborhood 1 zoning districts to align with those place types from the comprehensive plan. And again, single family duplex and triplex are allowed in the UDO's neighborhood 1 zoning districts. In the previous ordinance, single-family homes and duplexes on corner lots under certain conditions were allowed, but for most lots, duplexes weren't allowed and triplexes were not allowed in the comparable zoning districts. So the neighborhood 1 zoning districts, again, are designed to respect the character and development pattern of Charlotte's established residential neighborhoods. And the intent of the sidewall height and the building height setback plane regulations found in UDO section 4.3.D.1 is to maintain the character of established residential neighborhoods by controlling the height and mass of infill duplex and triplex dwellings in order to make them compatible in scale with the existing homes. The next slide is additional consideration, and this shows you on the top in the N1B zoning district what our regulations may have allowed if we had not included the sidewall height. So this just allowed someone to go to the 48-foot maximum height. And so you can see on the bottom where you have a two-story home on one side, one story on the other, the impact of having the 20-foot sidewall height maximum and the better compatibility with the neighborhoods. Exhibit 22 are additional considerations. As we developed the UDO, it was a multi-year process with significant feedback. We presented the sidewall height concept to multiple audiences throughout the development process. Based on community feedback, we did increase the maximum sidewall height from 12 feet to 20 feet to allow two-story buildings. Originally, earlier drafts had a 12-foot maximum, and we heard from many folks that that was not adequate. There was not an option discussed to increase sidewall height by increasing side setbacks. Again, the increased sidewall height over 20 feet, other than averaging taller adjacent sidewall heights, wasn't contemplated or discussed. And increasing the sidewall height through increased side setbacks does not meet the intent of the sidewall height standards, again, to maintain the character of established neighborhoods by controlling the height and mass of the infill duplex and triplex dwellings.
All right. Exhibit 23 is the appeal criteria. The UDO Board of Adjustment may reverse or affirm wholly or partly, or may modify the administrative or quasi-judicial decision appealed from, and shall make any order, requirement, decision, determination, or interpretation that ought to be made only upon finding an error in the application of these regulations on the part of the officer rendering the order, requirement, decision, or determination. The board shall have all the powers of the zoning administrator when you make the decision. Can you do that?
I just wanted to, if the board had questions about the information that staff's providing about the intent of the ordinance, I just wanted full time. Can you all hear me? I just wanted to offer some legal authority about what courts consider sometimes when there is a debate about how to interpret a zoning ordinance. What the courts will look for is the legislative intent. So they try to ascertain that and effectuate the intent of the ordinance. So which is why staff is presenting you this evidence about what they believe to be the intent of this particular provision. So I do have, I probably would mark this as Government Exhibit 27, just and offer this as part of the record. And I have copies for you.
Lisa, does that conclude your presentation?
Not yet.
Okay.
We can do exhibit number 25. Exhibit number 25 is staff's draft conclusions of law that the UDO Board of Adjustment upholds the zoning administrator's determination that the sidewall height cannot be increased due to the above language in the UDO. Article 2 has two separate definitions for building height and sidewall, which are independent of each other. Article 4.3.d.1 and the building setback plane drawing labels the sidewall height as the maximum height of 20 feet or the average height of adjacent building sidewalls, whichever is greater. The maximum sidewall height provides flexibility of building design while maintaining the appropriate transitions to adjacent and surrounding land uses. And if we go to the next slide, this is a photo of the subject property. And we have, I believe, folks that have signed up to speak in opposition, and applicants are also going to present. If you have any questions for me or Laura at this time.
Does anybody from the board have questions for staff?
Explain one more time about the exception to the 20-foot height requirement. If the buildings on either side are taller than that, then what's the percent? How many feet? Just say that one more time.
Certainly. And maybe if we could go backwards to that example, the graphic, but if you, actually the one with the three, yeah, on the, so if by chance you had a 20-foot sidewall on the left and a 25-foot sidewall on the right, you would average the 20 and the 25. So your maximum sidewall for the property in the middle would become that average 22.5. So it's to allow for the context to dictate taller sidewalls.
But that doesn't affect the actual roof line or the dormers, you said.
Your roof line, your building height setback plane would start from that 22.5 in that case instead of 20, and then go up 1 for 1.
Any other questions for staff? All right, hearing none. Thank you very much. Applicants, you may proceed with your presentation if you have one.
Thank you. And Mr. Wilson, may I ask a brief question of staff while we have them? Are there any current pending amendments to the UDO relevant to this section?
We have a cleanup text amendment that we are making for many sections to clarify standards.
Okay, and is section 43D or 4.3.D in that cleanup amendment?
It is in there. We found, because we had the appeal, that there needed to be some additional clarity.
Okay, do you know what that additional clarity is by chance?
It is just, it's actually kind of rewriting that section to clarify the difference and the separate sections for sidewall height and for the building height setback plane.
So it's intended to kind of differentiate between the two, I guess is what you're saying?
Yes.
Do you by chance have a copy of that amendment, or is that available for our review by chance?
I don't have it with me today.
Okay, but so it's intended just to kind of clarify that section is what you're saying?
That's right. We because we had the appeal, we thought it was clear, but because we had the appeal, then we thought we need to go ahead and deal with that.
Great, thank you so much. Thank you, I appreciate you allowing that. Good morning. Morning still?
Yeah.
I think, members of the board, my name is Allie Davidson. I'm an attorney with Moore & Van Allen, and I'm here today on behalf of the applicant. I figure before we get started kind of into the primary reason why we're here, we'll give you a little bit of background into our applicant and why we're here today and his personal background. So I'll let Mr. Radcliffe introduce himself. Just briefly, if you can just tell us who you are.
Okay.
What brought you here?
My name's Connell Radcliffe. I was first upon this property, well, a little bit of my experience. I started in 1984. I've got, almost 40 years of development experience. Took a company public in the real estate arena as a real estate investment trust. Started a company in 1999. We developed retail, multifamily, and mixed-use developments. We've built many multifamily projects. The only one we have close to here that we developed was in Huntersville sometime ago, I think about 4 or 5 years ago. So I've been doing that for, as I said, in the Carolinas for about 35, 40 years.
And can you tell us a little bit about this property in particular?
Sure. We were out looking for, actually pursuant to the UDO, the opportunities that might present themselves for triplexes or duplexes in the Charlotte area. We looked for about 5 or 6 properties, came across this property. We liked the neighborhood. We liked what's going on in the neighborhood with the newer homes being developed down the street. And we liked this particular lot, this particular property because it had 2 lots and allowed us to put a little bit, a total of 6 total. So that's how we came across it. That's basically.
And when did you purchase this property?
We purchased it in March of this year.
Okay, and have you taken any steps to start the development process for this
Yes,
property?
a lot. We engaged our consultants whenever we come into a particular municipality, we seek out the best and most qualified consultants for civil engineering, architectural, et cetera. So we've done that. One of them is Jeff Orsborn, who's here, can answer some questions if you have those. And then Axiom Architects is our architect. And we look for somebody who's got a clarity and transparency with the UDO, the guidelines, the setbacks, anything that you can and cannot do, because they've obviously got experience with that and we don't. So we look to them for guidance as we design this. So we began our civil engineering and architectural work probably in April, May. We've submitted a sketch plan and we actually have submitted our signed plans. And I think it just got through the gatekeeper. So we're in the queue now.
Okay, great. Thank you, Mr. Radcliffe.
I'm sorry, what are you planning to build on this?
Well, there are 2 lots and the ordinance allows for 3 per lot. So it's a total of
Duplexes or 3?
triplexes. No, 2 triplexes, I'm sorry.
And the board, at this time, I will hand it over to Mr. Well, I'll let him introduce himself if you guys don't already.
Yeah, I'm Chad Spencer. I'm recently retired from the city of Charlotte. I'd worked here for 26 years in the planning department. Assisted Laura and a bunch of team members on the UDO, and my last 8 years here was zoning administrator.
I'm going to walk us through more technical aspects of this presentation.
Yeah. So the good thing is, I think I agree with staff on like 85% of everything that was presented, and probably the slides are going to be very similar to the slides you just saw. So let's go. Where you go? Oh, there we go. All right. So as Mr. Radcliffe already talked about, this is the site. So I think you've already seen the slides regarding the site on the government's exhibit. So this is applicant exhibit number 2, which again is the site on the corner of Arnold and Cosby. And the property is zone N1B, neighborhood 1B. And so this is applicant exhibit number 3. And so this is just the beginning of the building height regulations for the N1 district. And I know Laura has already gone over some of this. But what this does is establishes the maximum building height regulations for the various districts. And as I mentioned, the subject property is zoned N1B. So the maximum building height is 48 feet for that site. And I know we've already talked about the definition. So in Article 2.3 of the UDO is the general definition section. And for building height is the vertical distance between the average grade at the base of the structure and the highest point of the structure. And then items 1 through 3 are things that are exempted from the height calculation, with like chimneys, parapets, and things like that. And then slide number 4 is the main section that we are dealing with for this appeal. And if you know, the heading for this section is building height setback plane for duplexes and triplexes. It's not maximum sidewall height for duplexes and triplexes. And it just has these criteria that establishes that maximum, the building height setback plane. So I'm going to kind of just read through some of these generally, or just very quickly, and then on some later slides, I'm going to go into more detail of what some of these subsections mean and what some of the terminology is in these subsections. So building height setback plane for duplex and triplexes. So in addition to the maximum building height requirement, which is 48 feet for this zoning district,
all duplex and triplex buildings within the neighborhood one zoning districts shall meet the building height setback plane regulations below. So all these regulations is what they must comply with for duplexes and triplexes. So the first one, which is A, that's the one that's the main point in this appeal. Because what it says is all duplex and triplex buildings are limited to a sidewall height at the required minimum side setback. And that's important. I'm going to define that in a later slide as well. It's defined in the UDO, but required minimum side setback. So at that location, the sidewall height is limited to 20 feet. And then it goes on to read and talks about, like I think you asked the question earlier about how you can go above 20 feet at the required minimum side setback, depending on what the structures are on abutting you. So if they have a higher sidewall than say 20 feet, say they're both 25 feet, then you can have 25 feet height for a sidewall at the required minimum side setback. And then in order to do that, you also have to provide a survey, which is at the very end of that section. And then B talks about that if there's no other residential buildings on that block face, there is no sidewall limitation. You can go straight up to 48 feet at the 5-foot required minimum side setback. And then C is what defines what a building height set plane is. So what it says is additional building height is granted at a ratio of 1 foot of additional side setback to 1 foot of height, establishing a building height setback plane at 45 degrees. Buildings may not exceed the maximum building heights of the zoning district, which again is 48 feet. So that's your building height setback plane here. And then D talks about how certain portions of the building may extend and go through that building height setback plane. And so it's dormers and gable ends. So that's illustrated here. Now, so again, the wording in this section indicates that sidewall heights for duplex, triplex is limited to 20 feet at the required minimum side setback. All right, so now applicant exhibit number 5. We're going to focus in on the section A. And again, I'll read again, all duplex and triplex buildings are limited to a sidewall height at the required minimum side setback of 20 feet. So we're going to start defining some of these. So again, we go back to Article 2.3, which is the general definition section of the UDO. So sidewall, which was defined earlier, but it's a wall that forms the side of a building. So it's part of the structure, part of the building. And then it is measured a little differently than how building height is measured. Sidewalls are measured from the finished floor elevation of the main floor to the eave, or if no eave is present on the structure, to the bottom of the finished roof plane. So that's a little different than how building height is measured. But the most important definition is the required side setback. So you give in the ordinance and required setback, that's C setback. So we go to setback. There's various types of setbacks. You got a front setback, rear setback, side setback. So then subsection 3 in that definition is the one that addresses the side setback. So a side setback is a required setback located along an interior lot line that divides the lot from another lot. So then for this zoning district, N1B, we go to table 4.4-2, and you look at N1B, minimum required side setback, it's 5 feet. So based off of the wording, the plain language in A subsection, all duplex and triplex buildings are limited to a sidewall height at 5 feet from the side property line of 20 feet. Now, if the wording was meant to restrict the sidewall height to 20 feet for the entire site, the wording should have said all duplex and triplex buildings are limited to a sidewall height at the established side setback, because here's another definition I forgot to mention. Well, here it is. Established setback. That's also in the general definition section. So you have a required setback and established setback. Established setback, in this case, because it's a side established setback, an established setback is the area between the side lot line and the building line of the principal building. So when you look at this exhibit here, this is part of that definition in Article 2.3. The white rectangle is the principal structure. So the established side setback is whatever that distance is from that side property line. So if that's 5 feet, which is the minimum, then the established is 5 feet. If that structure is 9 feet from the side property line, then the established side setback is 9 feet. But the required minimum side setback is always going to be 5 feet, because that's what it is according to that table. So then applicant exhibit number 6, now we're going to focus on C and D of this article. So again, the C is where it defines the building height setback plane. And you kind of have to look at the graphic to understand that a little bit more. So what it's showing is, so additional building height is granted at a ratio of 1 foot of additional side setback to 1 foot of height, establishing a building height setback plane 45 degrees. So when you look at the graphic, it indicates minimum required setback. So that's going to be the side, because that's the side lot line. Minimum required side setback, which in this case for N1B is 5 feet. Then you go up 20 feet, which is that sidewall height. That's the restricted at the minimum required side setback. Then that starts the point where the building height setback plane is, the 1-for-1 or 45-degree angle. Then it goes up to the maximum building height for the district. That's what cuts it off. It can't keep going forever. It cuts off at 48 feet for the N1B zoning district. And then when you look at D, this is the provision that allows for certain portions of a building to extend into and through the building height setback plane. This includes dormers and gable ends of the structure. So this implies that all other portions of the building are allowed additional building height per the 1-for-1 ratio, but must be below the building height setback plane that's established. A sidewall is defined as being part of the building or the structure. So therefore, the sidewall portion of the building is allowed to increase in height above the 20-foot limitation at the required, because the limitation at the 20-foot required minimum side setback per the building height setback plane, when additional side setback is provided as stated in C above. You know, additional side setback 1-for-1. And what this did, the building height setback plane does, it kind of creates a tent. So you go over whatever the minimum required setback is for the district. In this case, it's 5 feet. And again, you get 20 feet, and the 1-for-1 up to 48 feet. So you're creating a tent in which the house or duplex, triplex must be within. But if you're on that minimum required side setback, that's 20 feet. So this is just a recap of the terms and definitions that's associated with the height plane regulations of Article 4.3.D1, which creates that tent that the building must be within. And this tent that's formed by the building height setback plane regulations for duplexes and triplexes is to help maintain an appropriate transition of height between the abutting property and the developing duplex and triplex, as stated as part of the intent that was stated earlier. So again, you got the building height, which is the vertical distance between the average grade at the base of the structure and the highest point of the structure. So here, all the way up to 48 feet. That's the maximum height for the N1B district. Then you got the required minimum side setback is the required setback along the interior side lot line that divides the lot from another lot. N1B, that's 5 feet. Then you have that 20-foot sidewall height limitation at the required minimum side setback. So you have 20 feet, and at that point, that's where you start the building height setback plane, which is at 45 degree up until you reach the maximum building height. And again, this yellow is the tent in which the duplex or triplex can be located. So in this applicant exhibit number 8, this is an example of how the sidewall may exceed 20 feet in height when the building has an increased side setback beyond the required minimum side setback. And the building and its sidewall is below the building height setback plane prescribed by Article 4.3.D1. So in this case, here's that 10 again. Over 5 feet, up 20, the 1 for 1. So here's the sidewall. It's not at the minimum required side setback. I don't know what that distance is, not to scale, but it's not there. So therefore, it can go up higher, but it still has to remain below this building height setback plane, which again is the title for this entire section. And then this is showing how the dormer, it does state how a dormer can encroach beyond that building height setback plane. So here's the conclusion. So based on the evidence and testimony provided in the below findings, and basically just the plain language of the ordinance, of the UDO, and the terms within the UDO, it is requested that the board reverse the administrative decision that the sidewall height of a duplex, triplex within the N1 zoning district may not increase above 20 feet, even if the sidewall of the building remains below the prescribed building height setback plane per Article 4.3.D.1 of the UDO. And I'm gonna grab a drink real quick. So here's some of the findings that we see. The title for this article is Building Height Setback Plane for Duplexes and Triplexes, not maximum sidewall height for duplexes and triplexes. The intent of this article was not to provide, the intent of this article was to provide increased building height as the building shifts away from the side property line. They're creating that transition. So if you're not going to build like, and we'd have to go back, but there was a government exhibit, it was number 21. It showed 2 single family houses on both sides and then straight up 48 feet. That was not an accurate depiction because it still has to remain below that 10. So you go 20 feet, and then you go that 1 for 1. You can't just go straight up 48 feet, which kind of what that one illustration looked like. Then in this article, it only limits the sidewall height to 20 feet at the required minimum side setback. Again, this is 5 feet for the N1B zoning district. If the building shifts away from the required minimum side setback, the sidewall is no longer limited to 20 feet in height per the text of the UDO, since the sidewall is no longer located at the required minimum side setback. There's no text within the article nor any other portion of the UDO that prohibits increasing the sidewall height from 20 feet once the structure is shifted further away from the required minimum side setback and remains below the building height setback point. Article 4.3.D.1 provides for a building height setback plane, which allows for an increase in height as the building shifts away from the required minimum side setback at a ratio of 1 foot of additional side setback to 1 foot of height. Per the UDO definition, the sidewall is the portion of the building that forms the side of a structure. Therefore, this portion of the building is subject to the building height setback plane once it is no longer located at the required minimum side setback. So, and then if the sidewall height for duplexes and triplexes is intended to be limited to 20 feet for the entire site, the article should have stated at the established side setback, per the definition of established setback. rather than at the required minimum side setback per the definition, because that's 5 feet from the side property line. And that's all I have. And again, we just want to say, we don't really think it's ambiguous the way the wording's written. And so the plain language of this ordinance should apply, which I'm just gonna scroll back to this, where it says all duplex and triplex buildings are limited to a sidewall height at the required minimum side setback. And per the definition, that's not 20 feet away from the side property line. If it's 20 feet away where the structure starts, that's the established side setback. And that's all I've got on that. You have any questions?
Any questions for Mr. Spencer before we move on to another presentation?
So what, Shed, what is the app? Asking for a higher building, is that what it's requesting?
No, the building would be within this 10. The building, actually, I think, was it 30 some feet from the side property line?
48.5 feet from the setback line, 55 feet from the property line.
So from the side property line, the structure is 55 feet away from the side property line, 53 feet away from the side property line. They're wanting to go, I believe their sidewall is approximately 30 feet, but they're 53 feet away from the side property line. The 20-foot sidewall limitation is 5 feet from the side property line.
So basically, you're asking for another 10 feet of wall, what they're asking.
We're asking for it to be, it's going to be within the building height setback plane. Because let's see, they would be, so if this is 5 feet, just if it was, their building's over here, so they're going to go up here. Well, let me show you this one, yeah. So mixing up between the pointer and the other one. All right, so there's 5 feet, that's 20 feet. Say they went over 5 more feet, so that's 25 feet. So they would just say, for example, they want a 25-foot sidewall, but it's within the building height setback plane, and it is not located at the minimum required side setback.
So
they've increased it.
Yes, I think what the question, so we're not really reviewing a variance. We're reviewing a interpretation of a regulation. And so the applicant is saying that their interpretation of the regulation is that they are allowed to build X building. And there's been an interpretation that says you cannot build that X building. And they want us to then resolve that interpretation. Yeah, so he's right in saying he's not asking for additional. It's his interpretation that that's what the code says.
Well, that's pretty good. Okay.
And just to clarify, the staff's determination on this is that the sidewall height goes all the way across the property. No matter where if you start your building here, you have to stop it at 20 feet, even though it still falls below what this article describes as the building height setback plane. Because it's no longer at the minimum required side setback.
And I was note for the board's consideration, the case that was provided by staff also helpfully notes that words and phrases shall be construed according to the common expressed usage of the language. The technical words and phrases that may have acquired a peculiar or appropriate meaning in law shall be construed and understood according to such meaning. So as Shad walked us through, there is a defined meaning for established setback, side setback, and there's also a defined meaning for minimum. Required minimum side setback, which is a specific language in the EDO that we're asking to convert. I was remember that.
That's true. And as the staff said, there are two separate definitions, one for sidewall and one for building height. Staff has said that they believe that they apply differently, and there was an intent in the regulation. So that case was not for the purposes of saying that there weren't any specific definitions for either one of those, but to the extent that there obviously is a debate about how to interpret that particular provision of the ordinance, courts have said that you can look to the intent, the legislative intent of in this case, it would have been the city council in adopting this particular ordinance provision.
And so I think
Yeah, I think I appreciate what Ms. Hagler-Gray has noted and that we don't disagree. I think the issue when intent comes into play is when there's an instance of ambiguity. But in fact, this particular provision is very specific. It doesn't leave out required minimum side setback or leave out established side setback and just say generally the sidewall height requirement is X. It specifically says the sidewall requirement is 20 feet for the required minimum side setback. And I think that may speak to a little bit about what the amendment to this provision may be clarifying at a later date. But unfortunately, we're here today under this specific language, which we would argue is specific and without any ambiguity must be read by its defined terms.
Can you please point out where you read
Yes, it is on page 3 of Long v. Currituck. And there's a little star bolded 59, but it's about the third and a half, fourth paragraph down.
It's the paragraph before the block quote. Okay. So on the second side to the page, you see the block quote over here. It's the paragraph right above it. I would also note to the board that Ms. Hagler-Gray had a response if she still wishes to speak.
I would say that I don't think that the staff is saying that there's any ambiguity. That's not the staff's argument.
Just so I'm clear though, Shad's point, he makes it in email as well, is very important, I think, right? He's saying, why didn't we say in the UDO, maximum is 20 feet? Why didn't we say that? And why did we specifically say it has to sit at the required setback? The word, I'm confused about why that wording, specific wording is put in there by city council at that, exactly what they just said. Why didn't we say, that's it, 20 feet?
Well, I would also say that when that was pointed out to you, that provision did not go on to say 20 feet or whatever the language is, the average minimum, what is the language? It says 20 feet.
I have it.
Help me up. In that first paragraph, where is it? Where is it? Oh, it says 20 feet or the average height of the residential building sidewalls on both sides of the lot, whichever is greater. So read on, it does allow for there to be additional sidewall height when you take into account the context of the neighborhood. And so that is the houses on either side. And also that last line of 43D1A says if a sidewall height of greater than 20 feet is proposed, a height survey of the closest residential building sidewalls is required at the time of permitting. So the provision does take into account that there can be additional height for sidewalls. And if that's the case, then you should be looking at the closest residential buildings to determine that it's in context.
And then I would like to follow up. I mean, I agree with the wording, but I think it means something a little different than what's being said, is that at the required minimum side setback, the sidewall is limited to 20 feet. But then if you have a house to your right, a house to your left, that's 25 feet. Then if you do at the very last sentence, if a sidewall height of greater than 20 feet is proposed, a height survey of the closest residential building sidewalls is required. So that's asking for, you got to do a survey of the house to the right and to the left to verify that it's 25 feet. And then if it is, then you can have 25 feet at the minimum required side setback. Not established. That's just where the house sits.
Yeah, triplexes, residential. Is it common to look at building heights, and measure from a, certain height at the minimum setback? Say if you're doing a downtown office building, you got minimum setback that can only be so high. But it seems like I've always heard about you step it back and you get different heights.
There were components of that, and actually, and I wasn't really sure I was gonna get there, but here's the pre-UDO, just for an example. This was the pre-UDO regulations there was a height plane requirement for residential districts. Now, this didn't apply just to.
We would object to say that that's not applicable because it's.
It's not applicable. He was just asking.
I'm trying to go towards the guidance of the overall UDO document.
Okay.
Because this is not the only circumstance that talks about height, correct? Because every single zoning condition has a height requirement.
In the UDO, there is
Are there other places that has a similar treatment of a sidewalk? If I'm building a gymnasium at Queen's University or something like that, is there a condition that a sidewall has a requirement? And in those other zoning designations, is there similar language? And I'm looking for intent, because if there's an intent here, there may be intent scattered throughout the document in other places, and maybe that's consistent.
There is a provision in the UDO and for just about every zoning district that if you're within 200 feet of an N1 place type, then there are limitations on the height, but not a sidewall. So like from 0 to 100 feet, it's limited to 50 feet in height. And then from 100 to 200, you're limited to 65 feet in height. And then once you pass that, then whatever the zoning district is.
And that doesn't talk about sidewalk.
No.
Just have a question for our city attorneys. I know that we're not looking at approving or denying a variance here, but do the conclusions of law still apply in this case? And what I mean by, I guess my question to Shad is that, wouldn't this change the characteristics of the neighborhood in which this house is in?
So, Mr. Chairman, what you're looking at in this particular appeal is to determine whether or not the zoning administrator made an error. That is your standard of review. That is what you're here to determine. Your final determination will change as you read, when staff read out the applicable portions of the zoning ordinance, of the UDO ordinance as it pertains to appeals from an interpretation. When you make that determination, if you decide to reverse or modify in any way, at that point you sit with the hat of the zoning administrator. You are making a decision on what this zoning provision is going to mean, not only for this particular property, but moving forward. And so again, reminding you of your standard of review of what you're here to look for. You are here to determine whether or not the zoning administrator made an error in making this particular interpretation.
And I would note, in agreement with that, there has been reference to an amendment to this particular area. So while your decision would be binding upon your interpretation of this particular provision, should it be amended at a later date, I think it would be less relevant and/or inapplicable to the amendment, because the amendment will change, presumably will change the language of this section as Ms. Harmon described. It's been rewritten. No, thank you.
And I agree with that as well, with respect to an amendment. But I would ask you to keep in mind that an amendment has to go through a public process, and has not been adopted by city council.
I was gonna say, and I guess to let the board know, we've received numerous requests from different entities throughout the community to make modifications. So we are So that is something that will be continuing. So I tell people even the previous ordinance, we had that ordinance for 30 years and we were updating it for the entire 30 years. So we'll always be doing that, and it's not a one size fits all and we stop and we're done.
I would advise the board, as with any case, you're reviewing the conditions as have been presented to you and the zoning provision as is current and as has been presented to you. And so future potential changes or not at this point have not been presented to you. As such, they should not be part of your consideration.
So just, not saying that this reflects our decision, but let's just say the board decides to not uphold the appeal, and let's say an amendment is considered and passed down the road, what will stop the applicant from coming back and then trying to?
I would say that that scenario is speculative in nature, and without having the full set of facts before you, it would not be proper for the board to consider such a fact. And so I would again steer you back to the facts that you've been presented today, both by staff and the applicant, and the current conditions that you are evaluating.
I have a question about the definition of sidewall and the established finished floor height. Is there a maximum height above grade that a finished floor height can be? And is a garage considered the basis of the finished floor elevation?
Are you asking that?
I
of
guess,
staff?
I guess that would be a staff question.
I mean, right now, I guess to say a garage could be, as part of, there's not a maximum height saying what your finished floor could be, because obviously there's, sorry, I can't. Right now, there is no saying there's a maximum finished floor elevation, because obviously due to grade and depending upon the structure and then, that foundation. And I guess to say, yes, a garage would count as part of that finished floor, depending upon that floor plan.
Okay, so you could have like a unoccupiable 6-foot wall space, and your finished floor elevation might be 6 feet above grade. But if you were occupiable or a garage, then it would start at the occupiable level or the garage.
I mean, we would still want to look at that plan to see where that finished floor is. So I guess to say it's possible how you've said it, but we would have to look at it depending upon what was submitted.
Right. And on your particular project, how high above finished grade is the finished floor level? Is when you say 30 feet sidewall, is that 30 feet from finished floor level that's 6 feet above grade, or?
Work off an established side setback. So that means that 5 feet, we could go, our height is actually 32. Okay, to be exact. So the sidewall could go an additional 12 feet and come up, but we're actually on that setback on 48.5 feet, because we're going to put landscape up. I do this in a lot of places, typically landscaping around the bottom is part of that. So we're actually, when we take the established. I just don't do this a lot. And respectful of the 48-foot height limitation we have on the front. So we understand there are two different issues. And again, our established sidewall is not at the 5-foot setback. It's 43 feet beyond, 48.5 feet beyond that. And we show landscaping areas, things of that nature to buffer, which we feel is appropriate.
I got it. So it doesn't sound like you're not, the finished floor level's not wildly above the finished grade, but it's roughly in the same spot. Or
Okay, are there any of them? I'm sorry, you got a response, Jen?
I mean, other thing I just want to note, when this is going to be a math problem here, but say with the building height setback plane, you go over 5 feet, you go up 20 feet to get up to 48 feet, which is the maximum for the N1B. That's another 28 feet. So with the 1-for-1 ratio, that's 28 feet. So to get to 48 feet, so 5 feet plus 28 feet is 33 feet. So at 33 feet from the side property line, you can be up at 48-foot max height. If you build the house or the duplex or triplex right on the minimum side setback. But our client is building this house or this duplex, triplex, 50,
Probably 53 and a half
53 and a half feet.
for the property line.
And he's being told you can only go 20 feet. But if he built right on the property line, he could be at 48 feet and 33 feet of distance.
This is a corner lot, right?
Correct.
And so are you focusing the driveway on what is now the front of the site? Are you changing the side of the front?
So they've done a recombination plat. So the property line used to do like this, now it's like this. So there's one structure that's facing 5 feet and the other one facing frontal.
So the one facing Cosby is the one I was talking about. That's 48 and a half feet from the setback line.
I think we also need to note that this is a sketch plan and we have not, I know they've said they submitted, but land development staff has not reviewed an official submittal, so
So basically, Shad, and from what I hear you saying that because your client has brought in their property a little bit more from the sideline, that allows them to still meet the regulations by the UDO and height.
Building height setback.
I have a question. I guess maybe for, for staff, are graphics within the ordinance considered complementary to the regulation, the verbal or the written regulation?
yes, the intent was to be complimentary so we could explain it. That was when we went to the UDO, because as you know, the previous ordinance, the Euclidean, it was all wording. And so what we did with UDO is we put in more graphics so that way everybody can see what we were trying to explain.
And if I can, they're actually in Article 2.1, which is under the rules of construction, and I don't have this on the slide, but it's in the UDO. It says, for the purpose of these regulations, the following rules of construction shall apply. And then A is illustrations, diagrams, and flow charts. Illustration, diagrams, and flow charts are included in this ordinance to illustrate the intent and requirements of the text. In the case of conflict between the text and any illustration, diagram, or flow chart, the text shall control.
And I think
so with definitions of terms, the text would control.
So I think what staff is written is saying there is no conflict between the graphic and our interpretation that we wrote.
Okay. All right. Are there any more questions for staff or for the applicant? And Lisa, we do have residents here that want to speak in opposition, and is all opposition, or there's some speaking in favor?
I would defer to April.
They're
all in opposition, April said.
Okay. Sorry. Okay. Any other more questions for staff? All right, hearing none, we will now hear from our residents who have signed in to speak in
Have
opposition.
them all stand and swear them in.
Yeah, I was actually gonna ask city attorney if we can actually do that, if we can have all of them stand and swear in at the same time, instead of having them swear in individually.
Yeah,
Okay.
you can have them all sworn in. The only thing I would advise the board is just to make sure when each and every one of them gets up and identifies themselves to confirm they've been sworn in so that there's a record of it for each individual.
Okay, all right, great. Okay, so I'll ask if possible, if all individuals who are wishing to speak, if you can just, for the time being, approach, I don't want to call it the bench, or approach the Bible at the podium, and then we will swear you in.
And Mr. Chairman, just to clarify, an individual may swear or affirm.
Yes.
And so to the extent that individuals would like to affirm, they don't need to approach the Bible, just to be clear for everybody.
All right. Okay. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Thank you. Okay. So, the first person that we will hear from, and please forgive me if I pronounce your name incorrectly. I'm just going off of what I can see here. Jasper Fahim? Okay.
So ask him to state his name and spell it.
Yeah, yeah.
I've lived at 1800 Arnold Drive.
Just a minute.
If you can just state your again, your name for the court reporter and your address.
Jasper Wayland Parham Jr., Parham.
And if you please just confirm that you've been sworn in.
Excuse me?
If you could please confirm you've been sworn in for the
Yes,
court
I've been
reporter.
sworn in. I've lived at 1800 Arnold Drive since 1986. I own the property. I didn't sign up for a 32-foot high end wall next to me. And I have no intent of signing up for one. The building would be too high, and it's closer to my property line, I believe, than any 50-foot setback.
Oh,
No.
we were going to ask him if he could show us where his property.
Yeah. Mhm.
That's my corner there. And the one of the proposed buildings right about here. Do you have the sketch plan?
I'm sorry, are you doing the applicant sketch plan? Sketch plan. Is that what you're asking?
Yes, ma'am. There's my corner right there. And then there's the end wall right there. In line of sight from my house, there's not even a 20, well, there, until 2 years ago, there was not even a 20-foot end wall. Now there is a 20-foot end wall across from me, but 32 feet is a bit much. That's all I got to say.
Thank you very much. And just want to remind our speakers, one, try your best not to repeat what the person ahead of you has said, and also try to stick to the facts of the case and not any opinions that you may bring. Thank you very much. Next, we'll hear from Holly Todd.
It's not to speak.
Stop and speak. Okay. All right. You're welcome. Next is Allison Randallin. Did I say that right? Okay. And when you approach the podium, could you please specify if you have been sworn in, and also say your name and spell it for the court reporter. So can you confirm that you've been sworn in?
Yes.
Okay, great.
My name is Allison Penland Randleman. Hello, is it on? My name is Allison Penland Randleman. And I live on the corner of 1844 Gray Bark Avenue and Draper. So I'm right up on the corner. So this is the entrance. When you come into our neighborhood, this lot is prominent. This is the entrance to Mary Oaks. I work actually as a designer for a local home builder, so I deal with a lot of this stuff just in my job. And one thing I know is taller, skinnier buildings are what builders want to build, especially in a townhome situation, because then you get more vertical height rather than, horizontal height. You can put more on a lot of the space of the land. It seems like roof height, being 48 feet, is really part of what they're focusing on, and not on the sidewall height of being 20, excuse me if I get anything wrong, I'm sorry, 20 feet. But the question is, does this squishing and going up but remaining within that 48-inch roof height, is that complying with the intention of the UDO? Is this being done because it's easier for the builder to put more product on the land? With creative design, bedrooms with clipped ceilings, things that builders don't like to do, they could comply with that 20-foot sidewall. But it's easier to get a garage space, a main living floor, and then bedrooms when you have more of that side space. So I understand why it's being asked. But once again, the question remains, does that comply with the intention of the UDO? Is it going to overwhelm the areas around and all of our homes that we love so dear? And is it going to look at home within Mary Oaks? Mary Oaks is a beautiful community. We want to see it thrive. We know it's going to change. I just wanted to do it in the right way. Thank you very much.
Thank you very much. Next, we have Brad Hagler.
I'm not going to speak.
Oh, okay. All right. I should have seen that, yeah. I was like, there's a lot of people.
Shad's already done it.
Shad, you already spoke, okay. Connor Ratcliffe? Okay, oh, sorry, you already spoken, okay. David Bonner? Bonner. I'm so sorry about that.
And all of a sudden, but one calls the Connor. Joke is on. So David Bonner, B-O-N-N-E-R, and I have been sworn in.
Okay.
No worries, it happens all the time. So I am Jasper's nephew. I've been performing a lot of work at his house because of water issues. The lay of this land actually slopes downwards to his house. Cosby is pretty much level. It is about 35 feet above Jasper's house. So already the foundation, first floor, what have you, sidewalk, it's going to be above his house. So when he speaks to the sidewall height, and I agree everything that government and staff have shared, the 20 feet or their desire to go to 32 feet based on the sketch plan that's been provided would mean that you would have a building towering 75 feet over my uncle's house, a one-story house. So the 2 yards on either side, as the government said, I think they have a built-in dormer gable. The finished floor height is 9.5 feet. So you're going, the 20 feet is already greater than the adjacent properties. One of the diagrams that was shown in the applicant's presentation, I think it was Exhibit A, I felt was a little bit misleading because it seemed to indicate that that was part of the UDO and not the diagram that's actually contained in the UDO. So I did want to make that very clear. Also, the question that came up on finished floor, it was Exhibit 8 on the applicant. The finished floor elevation question that came up, typically I come from DC where there are a lot of townhomes, as Allison was pointing out. Most of the time that main floor does not occur until you take up a full flight of stairs. So even at the 20-foot sidewall height based on the UDO, I mean, they're already gaining 10 feet because these are garage townhomes with a small room behind them based on the sketch plan provided. I want to make clear that that is a altered drawing. That is not the drawing that's in the UDO. So I do not think that was clear during that presentation. So it kind of seemed to indicate, because the diagram, the UDO actually says, going back to the legislative intent, that it is 20 feet max or the average of the adjacent sides. So, and again, that adjacent average is about 9.5 feet. So the other part of it is that the EDO says that the goal is to retain the identity and charm of the neighborhoods, in particular with the N1B classification. This sketch and the appeal to interpret the language that they can get additional height due to additional setback destroys goal 9 of the UDO, which is to retain the identity and charm of the neighborhoods. Additionally, in the executive summary of the UDO was never meant to be a concrete, never changing document. As pointed out earlier, it is supposed to be interpreted and left for intent. So that is all I have for us right now. So thank you very much.
Thank you very much, Mr. Got that, that's done. All right, okay. Next, we have Brian Simpson. And if you can please indicate if you've been sworn in and spell your name out for the court.
Yes, I have been sworn in. My name is Brian Simpson, Simpson. I'm a resident of Mary Oaks community, a little bit further down the road. I am a registered architect of the state of North Carolina and often do have the opportunity to serve multifamily clients of middle and larger scale developments. The exhibits shown have given me even some clarity too, and some idea of the context of the neighborhood, as well as what is allowable in the UDO. Our neighborhood does have several duplexes that exist within it, and they blend well within the context. They've been there for just as long as the neighborhood's been there, as far as I know. Laura did a great job of explaining some of the intent of the UDO and kind of how I view and agree with the UDO as far as what the intent is there. I'm trying to keep buildings within the context, and we do need to have new development. The city needs a lot of additional residents, right? We have a lot of people coming here. But at the same time, we do need to maintain the character of what's existing. If we could actually break up the proposed site plan, there's a couple other things I had some thoughts on, but I do agree with the application of the sidewall restriction as I, as an architect, would understand it. I feel like that is a separate and defined well as that differently than the overall building height. But if you look at the site plan, something else I'm kind of pointing out is the intent of the UDO, in my understanding, is that these triplexes are supposed to be self-sufficient and independent of each other, which is why you can only have one per parcel. So there's 2 separate parcels here, which, minus the sidewall, if the sidewall is sorted out, they could technically comply, right? But what I am seeing is on one parcel, you have a detention basin being placed, as well as what is a 15% green area reservation. It's not clear to me what that is exactly. And then you have parking being shared between the 2 parcels. So there are elements that are supporting both parcels that are, in my understanding, intended to be self-sufficient and independent of one another to prevent larger scale development. But because those are being combined, those elements are being combined to support both, you can build a higher density on that. So I'm just curious if there is somewhere in the code or in the ordinance that does allow for that sharing. That's just something I've seen that I was not really clear to me, kind of reading through and trying to read through the hundreds of pages of the UDO. But, you know, if it is not written, if it is not a written policy, maybe we need to have some clarity on that as well. Thank you.
Thank you very much, Mr. Simpson. Now we'll hear from Rose Black. Rose Black here. Okay. All right. Next, we'll hear from Randy Sig.
Sure.
Okay.
I have been sworn in, and my name is Randy Sig, S-I-G-G. I want to say at first that appreciate the time that the board takes to review all this stuff that's going on. And
yes, a lot.
Thanks for your patience and your concern on our behalf. And I'm thankful for the UDO and for the time that they took to come up with regulations so that the character of the neighborhoods could be, sustained. We've lived in our house. We're on Graybark Avenue, the first one on the right on Graybark Avenue. We've been there since 1976. And the fact is that this is our house was built in 1950, and this is definitely a 1950s neighborhood. And it is just a sweet, sweet atmosphere and character. Over the last several years, there have been several what I would call knockdown rebuilds, and all those that have happened, I feel like for the most part have maintained a good character in architecture of the neighborhood. That it definitely is a single family home neighborhood, but it's also it's a neighborhood of trees, and I'm not sure. From the plans, I know close behind the original house that's since been knocked down, there's some pretty large trees that go back to the end of the lot. I don't know if they would be clarified as heritage trees, but but that would be a concern if they would have to be removed from that. So. As I've listened to everything, I agree with everything that everybody has said about opposing this. This is a high point, grade-wise, this is a high point of the neighborhood. So as you come up drive to go around that pretty steep curve, anything that's, 40 or 50 feet high, it's just going to stick out. It's just not going to fit in with that and blend into the character of the neighborhood. I've sat here, I've listened to Mr. Ratcliffe, right? You look like a good, honest man. You've been in business from 1984, since 1984, and I'm sure if you've been in business that long, you must be doing good work. And my recommendation would be to follow the board. It looks like we're going to be stuck with these triplexes, but just keep the heights low. The best thing I would suggest to build 2 or 3 single-family homes, and the neighborhood would welcome those families and welcome you to do that. Thank you.
Thank you very much, Mr. Sig. Next, we'll have Daniel Lasher. Is Daniel Lasher here? Okay. Is it Toya Sig?
It's Taya.
Taya, my apologies. Okay.
It's okay. It happens to me all the time. So Taya Sig, S-I-G-G, last name. there's 1818. I'm right north of that 1824, and we've been there forever. And this neighborhood has a lot of foot traffic, especially because of COVID. We had a ton of foot traffic. And I think with building these and building them as high as they are, it just creates unsafe issues, especially along Arnold Drive. That is a blind curve. And if your driveway for your triplexes is coming in that way, it causes a lot of issues. And it's also going to cause a lot of issues with people building there and then trying to park along Cosby and Arnold with that being a blind drive. So I'm just here to oppose that. I think these plans are not great for the neighborhood. I don't think they maintain the character of the single family homes in the neighborhood. It doesn't contain or keep up with the identity and charm of the neighborhood. And I feel like they're just there to maximize profits. Thank you.
Thank you very much, Ms. Sig.
Make sure she was sworn in.
Yeah, Ms. Sig, she was sworn in, yes.
Thank you.
Okay.
And Mr. Chairman,
Yes.
before we continue, just to emphasize to the board that opinion testimony about safety, traffic, and other related matters need to come from experts. And so to the extent that any of that testimony is being provided to the board without the appropriate foundation, the board should disregard.
Next to speak is Austin Seasgrave. Please confirm that you've been sworn in and spell your name for the court reporter.
I've been sworn in. My first name is Austin, like Texas, and my last name is Seagrave, Seagrave. I really want to speak today for the Browers who live right next door to the subject property. I know them well. We're good friends. I'm keeping their dog while they're overseas. They would be here today. They can't be here because they don't fly back until tomorrow. But they've had many discussions with the developer, I think, and they're definitely opposed to having anything being any higher than it needs to be. So I wish they could be here to speak for themselves, but that's what I wanted to speak to. Also, I want to speak to that height again about the street, because where Cosby, that intersection really is the highest point in the neighborhood. And when you go down that street, that's like when you're walking up, that is your heart rate's going up. Heart rate ridge, you're walking up. So I just picture myself, I live down in the gully, looking up at something that's, 48 feet tall and the huge walls like a castle on the hill towering over the trees. That's just not in keeping with the neighborhood, which are all like pretty much except for the new development, single family homes. Thanks.
Thank you very much. Our last speaker today is Mr. James iPage. Is that how you say it? Okay. And if you can confirm you've been sworn in and spell your name.
My name is James Page. Yes, I've been sworn in and they said the best for last. Yes, I am a hostile witness. I'm up to Cosby right about, I think I'm the next one right here. I've been around that curve probably 50,000 times in my life. I've lived there since I was 11 years old. I moved away briefly when I was an adult, but my parents always lived there. I'm a 57-year resident of the neighborhood. I understand change is coming. I'm not trying to be the old man out there hollering, get out of my yard. But the proposals for this, I rode around the neighborhood yesterday. There's 369 homes within Central, Eastway, the backside of Charlotte Country Club in there. There's 5 duplexes. Yes, they've been there since the very beginning. They fit right in with the neighborhood. What they're proposing to build here, if you look at the drawings, the back side of both buildings are going to be facing the street. And you mentioned in your thing earlier that you wanted everything to kind of look kind of like the neighborhood, Well, how does that look like the neighborhood? The back sides of them are going to be facing the street. And I've lost my way there for a second. But this is not in the neighborhood. I mean, it just doesn't look right. It will not look right. You mentioned earlier that you like the way, the builder, that you like the way the neighborhood was progressing with the new homes and all that. And there's probably about 40 or 50 of those already. There's 300 of us that still live in that neighborhood that matter too, than the little homes. So you need to take that into consideration. I'm strictly opposed to this. I realize I may be falling on deaf ears, but I just wanted to have my voice heard. And I appreciate it.
Thank you very much. Thank you. So that concludes the speakers that we have today. city attorneys, do we have to allow the applicant to respond to anything, or does that?
It's not a response. I just would object to any irrelevant or hearsay statements, but no other response.
Okay, thank you. Okay, now we will move into our deliberations. And as tempting as it is to address us during deliberations, you cannot. I know it's tempting. You're going to see us deliberating amongst ourselves. But we'll be moving to a period of deliberations. For the folks that are in the room, you are welcome to stay. If not, if you have to leave, we understand. But that's what we will do right now. So my fellow board members, you're free to speak on the case and indicate your opinions about it.
I'll go ahead and start. I think I'm going to be interested to hear what my fellow board members have to say. The things that I have been concentrating on is the fact that these are regulations that are set specifically for duplexes and triplexes. A single-family residential home is not held to the same standards as this duplex and the triplex, and can be the full height at the property line, not at the property line, but at the setback. And so these regulations were put in place for the special consideration of a duplex and triplex in a traditionally single-family neighborhood. So when I look at the intent and I look at the intention of the UDO to try to get these duplexes and triplexes to fit into the neighborhood, and I look at the verbiage where it does specifically talk about the limit on the height at the minimum setback line, it could be inferred to me as someone trying to interpret the meaning of that those that contemplated that regulation were envisioning duplexes and triplexes on very tight sites where the buildings were built up to the setback, and that there would be a challenge in making sure that those duplexes and triplexes fit into the character of the neighborhood. So, but that being said, so I also look at this illustration here where they talk about a minimum setback required and they talk about a 20-foot maximum height, and yet they illustrate that maximum height further in than the minimum setback, showing the intent of the sidewall being not just on the property, on the minimum setback line, but perhaps also within there. So those are the two things that are kind of pulling against me in both directions. I feel like the authors of the UDO have tried to illustrate their intent with this complimentary graphic that says this is the sidewall. If it's further in, it's still the sidewall. But to me, the verbiage is clear that this regulation is intended at the minimum setback line.
Thank you, Mr. Court.
I'll go next.
Sorry.
I'm trying to follow the edict that we're looking at the intent of this. I realize this is a very emotional issue. I knew it was going to be an emotional issue when they put it in the UDOs, because I live in a neighborhood much like this, that this could face me very soon. I think we're being nitpicky when we say it doesn't exactly say what I want it to say, so I'm going to challenge it because I want it to say something different. I think the idea of putting triplexes and duplexes, they put minimum height requirements in there for a reason, so they don't oversway and overtake
the surrounding homes. And I know that you can go to 48, and I understand that, but that's the 48 max. That's with the eaves and the roof line and all that. But the sidewalls, I think, need to stay within that 20, maybe 25-foot sightline to match the surrounding homes. So I am inclined to uphold the zoning administrator's decision as far as the height requirements for these triplexes go.
Mr. Williamson or Mr. Shea?
I can appreciate the idea. I think there's lots of flexibility in the way we interpret things. I think when we get into putting 6 units on a single family lot, I don't think there's a whole lot of room to divert from kind of what's written. I see the idea of moving in and getting the height adjusted, but I think that setback is it 20 feet or the average? And I just think we need to kind of stick with that. The duplex and triplex idea is already messy enough and is already gonna cause a lot of angst in this community, and I don't think we need to pour any more gasoline on that fire.
Mr. Shea?
No, I think to the point of intent that was brought up earlier, the way to get around the writing as it sits today is you slide the house back. You can have 48-foot tall or 40-foot tall, whatever you want, sides. I don't think that was ever the intention. So I agree with that thinking, but at the same time, the city is put duplexes and triplexes as an option in these kind of neighborhoods to help with providing housing. And so there has to be a balance, and I don't think that balance is here in this particular case. So from my understanding, from what I read, I agree with both staff and with the applicant that the writing is clear each way, depending on how you look at it, for sure. But the intention, as was mentioned earlier, I think is pretty clear to me.
All right, thank you very much. And I also agree with my fellow board members as well. I also feel like that it does change the characteristics of the neighborhood too. So I would be inclined to uphold the appeal. With that said, that ends our deliberations. And now we will move into voting. So just to make sure I'm reading this right, is there a motion to uphold or reverse the zoning administrator's decision?
I make a motion to uphold the zoning administrator's decision.
Okay, motion's been moved by Ms. Dryden to uphold the zoning administrator's decision. Is there a second?
Second.
Second by Mr. Williamson. Now we will move into a roll call vote. Ms. Dryden?
Dryden, yes.
Mr. Williamson?
Williamson, yes.
Mr. Shea?
Shea, yes.
Mr. Court? Court, no. Mr. Wilson, yes. So the zoning administrator's decision has been upheld. And that concludes this case for today. Thank you very much.
I would remind members of the public that this is still a quasi judicial board and there's still business before the board. If you could please, if you're welcome to stay for the remainder of it, but if you must exit, please do so quietly.
Next agenda item we have is, and I don't have an agenda in front of me. But
Minutes.
yeah, is approval of the minutes.
Mr. Chairman, the next item for the board would be the approval of minutes.
Yes. That's what I just said. Yeah, I just said that. No, you're fine. No, you are perfectly fine. Has members of the board been able to review the minutes? If so, is there a motion to approve the August 29th minutes of 2023?
Motion to approve the minutes.
Okay, there's been a motion.
Second.
By Mr. Shea, second by Ms. Dryden. Now move to roll call vote. Ms. Dryden,
Dryden, yes.
Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shay, yes.
Mr. Court,
Court, yes.
Wilson, yes. Now, is there a motion to adjourn the meeting?
I make a motion to adjourn.
Mr. Solomon, what is your request?
We have just some business.
Okay.
Okay, I see it on the agenda. What's the business?
Well, the business is an announcement that John Kinley has taken over my previous position as BOA Senior Project Manager. And John is coming to you with about 17 years of planning experience. And some of his early experience even includes Board of Adjustments for different municipalities. So the last 10 years, he's been in rezonings. So we stole him from rezoning. And John, if you'd like to introduce yourself.
Lisa summed up kind of my past history with working with other municipalities. Worked with the Western Piedmont Council of Government before I came to the city of Charlotte. So about 10 years ago, I dealt with a couple small towns that they contracted with, doing basically every job that a planner can do because I was the planner for those towns. So that did include working with their boards of adjustment, but not on a nearly as frequent basis as I will be working with you all over the next several years. So as I'm in this position, so look forward to it and just learning all about y'all's processes and helping Lisa and Solomon with board of adjustment related items.
But so you're taking over, but you're staying.
It's the new Lisa.
Lisa, she's promoted, she will still come in some of these times.
Okay.
John will be doing.
All right, so happy,
Lisa.
yeah. Congratulations, Lisa.
I'm zoning compliance manager, so I'll manage the commercial and residential zoning review teams.
So we're gonna try to fit in problems that keep showing up.
Oh, I'm so happy you're coming.
And,
We also have the August minutes that he's got.
okay.
And thank you, April, for sitting in tonight.
Yeah, for those of you who don't know, April is part of the old school zoning board. When I first got on, it was like what, 2016, I think I got on 2017, so yeah. Yes. Well, okay. That's it. Okay, I think we're in the middle of the motion of voting. All those in favor of adjourning, please say aye.
Aye.
Aye. Thank you very much.
Thank you.
There's tea next door if you want any sweet or unsweet tea.
So now that I've been immersed in this issue, can I unload my thoughts on somebody?